that's not security. This is violation. Please rise. The justices of the Appellate Division, Supreme Court, First Department. Please hear all persons applications of the Appellate Division. Draw near, give your attendance, and it shall be heard. Please hear.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. This afternoon, we have almost 7 hours of argument time that's been requested. So please, as I call the calendar, ask only for the time that you'll absolutely need to make your argument. Remember that we have your briefs, we have your record, we're fully familiar with the facts of the case. So please just keep that in mind as we go through the calendar. Okay, thank you. People versus Kashinia Margaret Pawaru.
Appellate request 5 and 2, Your Honor.
5, 2, and 5. Gaffney versus New York City Transit. Submitted. Pollock versus Cushman and Wakefield. 5, 2, and 5. Thank you. Jimenez versus PR Grand. I'll do 5 and 2 and 5. If you need more time, of course, we'll allow it. People versus Yellington Concepcion. 3, 1, and 3. Thank you. Hamway versus Sutton.
5 and 2, Your Honor. Responded.
5, 2, and 5. Thank you. Jaskaran versus the City of New York is submitted. Contreras versus MDG Design. 5 and 2 and 3. Thank you. People versus Michael Ishenko. Are both parties here yet? Okay. People versus Michael Ishenko. Appellant? The appellant? And the time you'd like?
5 minutes.
I'm sorry?
5.
Did you want rebuttal?
7.
Okay, I'll do 5 and 2. 5, 2, and 5. Largo, 613 Baltic Street versus Stern. 5, 2, and 5. Thank you. People versus Naftali Thomas Diaz. I beg your pardon? Okay, 3 and 1 and? 3, 3, 1, and 3. Thank you. Taxi Tours versus Go New York Tours.
Appellate request 5 and 2.
Your Honor, you said to respond.
7 for one party and 5 for the other. Okay. Choir versus City of New York.
Your Honor, appellant requests 5 on argument and then on rebuttal 5 because there are 2 respondents.
Your Honor, City responds to request 5.
There's only one respondent.
Okay, 5, 2, and 5. Thank you. Long versus Russ?
Appellate request 5 and 2, Your Honor. Respondent request 6, Your Honor.
5, 2, and 6. Thank you. Bartel versus Farrell lines and Bartel versus Maersk line? Okay, so I'm going to ask you to argue them together. Obviously, they're separate cases, but I'm going to give you, since there are many similar issues, let's do 6 and 2 and 6, and we'll give you more time if you need it. Domingo versus 541 Operating Corp. is submitted, and Lynx Asset Services versus Nestor is submitted. First case for argument is People versus Pawaru. Pawaru, sorry if I've mispronounced that. Go ahead.
May it please the Court, Samuel Steinbach Pratt from the Office of the Appellate Defender on behalf of Ksenia Pawaru. Ms. Pawaru was ordered to pay nearly $600,000 in restitution, but there is no evidence in the record to support that amount. In the absence of sufficient evidence, the sentencing court had an...
Counsel, at the plea, did they not say the amount on the record, the $585,000? That was on the record, right?
The court did say the amount on the record. That's true, Your Honor.
And then the defense counsel said that he was going to work the details out with the prosecutor before sentence, correct?
I would not quite agree with that characterization, Your Honor. I think what defense counsel said was he wasn't sure, or she wasn't sure that if a certain amount had been credited towards that amount of restitution anyway. But
either way, that would be done before sentencing and settled, right?
Yes.
And then at the sentence, the sentence went forward. There was no discussion as to, well, this is the wrong amount, we want to withdraw our plea. That didn't happen, right?
That's true, but what I would say to Your Honor is that, first of all, it's well established by the Court of Appeals decision in Consalvo and by other cases that the fact that a defendant pleads guilty with a restitution order and even agrees to pay a certain amount is not by itself sufficient evidence. And this Court's decisions in Soar, in Masagli, in White, very clearly...
Well, why isn't this a preservation issue?
Well, because this Court's decisions in Soar and Masagli very straightforwardly establish that this is an illegal sentence that is not subject to preservation and cannot be waived. I think Soar is really quite explicit on this point. Where the record doesn't contain a basis for the award, the issue is non-waivable and does not require preservation. And again, that's building on prior cases of this Court going back decades.
But that's when there's no evidence to support the amount. But there is evidence here to support the restitution order. And the Court did have the power to impose restitution.
Well, Your Honor, I would disagree that there was evidence to support this restitution order.
Well, the doctor there were affidavits from the doctor saying that it was up to $600,000. So the amount was there. I mean...
Well, there's no affidavit, Your Honor. There's a statement in the PSI that's attributed to the doctor.
A statement in the PSI. Okay.
But I would just say, I think there's pretty abundant case law, and we cite it in our briefs, that hearsay statements in the PSI are not sufficient to uphold a restitution order.
The fact that the defendant never objected to the amount of the restitution award. It was stated many times in the record what would it be, and the defendant never indicated in any way that she was unhappy or thought it was incorrect or requested an evidentiary hearing as to what the amount should be.
That was true in Soar and Masagli as well, and in both of those cases, this Court's decision explicitly notes the defendant agreed to pay the specific amount. Nonetheless, this Court held that was not.
Isn't the distinction that this case, there actually was a basis for that amount based on the doctor's affidavit of the checks, the amount of the check?
Well, I don't think so, Your Honor, because again, there's abundant authority that this sort of hearsay, unsigned, unsworn statement, never admitted into evidence, never formalized in any way, is not sufficient to uphold a restitution order.
Well, what about the fact that she never requested a hearing on the amount?
Well, again, that's true in Soar, it's true in Masagli, it's true in White. All of these cases confronted this exact issue, and the prosecution, I'll note, raised the exact preservation issue they're making now in Masagli. And this court had no issue rejecting it because—
Does it matter that she signed a waiver in this case? That there was, I'm sorry, that she pled guilty here with a waiver? Yeah.
The waiver, so there's two things I'd say about that. The first is there was also a waiver in Soar, but again, the court said very clearly, this issue is non-waivable because it is an illegal sentence. The second thing I would say is even if you don't think this issue is non-waivable, this waiver is clearly invalid for the reasons we lay out on our briefs, chiefly that the court misled Ms. Poirot into thinking that she would be required to sign a waiver, and it used language that this court has specifically disapproved of in the past.
Well, it's used differently here because she's not talking about something, I mean, when she uses the word require, she's gone on in a very detailed way with regard to a number of the issues, and then she's talking only with related to the bargain for plea in this case, and she says that given that specific circumstance, she's requiring her to plead guilty. In other words, she knows about this coming in, it's been discussed, it's the plea that she knows she's taking, and the judge very specifically says, with regard to that, because of that, I'm asking you to sign the waiver. Isn't that different?
I see my time is up. I made.
Yeah.
I think that I would disagree with the characterization that the court's language was clearly connected to the plea in a way that made it clear that this was separate from the rights that are normally forfeited by an appeal. But there's also several other issues with both the oral and written waiver, including misadvice as to, most importantly for this case, the circumstances under which an illegal sentence can be appealed.
Thank you.
Good afternoon, and may it please the court, David Gagne for the people. I'll just begin by stating that this court is barred from reviewing defendant's claim because she validly waived her right to appeal and she failed to preserve it for appellate review. The defense relies on Sori and Masagli for the claim that the waiver and preservation doesn't apply to her claim, but neither of those decisions addressed People v. Callahan or People v. Horn from the Court of Appeals. And People v. Horn stated very explicitly that a challenge to a restitution award for lack of record support needs to be preserved, and it cited to People v. People v. Callahan.
Counsel, assuming for the sake of argument we don't agree with you on the waiver, does ability to pay play any role in determining the amount of the restitution?
Not for the only restitution order that is currently in effect. The second restitution order was accompanied by a prison sentence, and therefore there was no requirement that the court consider the defendant's ability to pay.
That's because it's under Penal Law 60.27.
That's correct, Your Honor. The court was required to consider her ability to pay at the time the initial restitution order was issued.
But even if that was the case, I mean, the fact that she came up with $200,000 within a matter of weeks, as well as had, I guess her brother had given her $95,000 at one point, why isn't that indicative of her ability? Is that indicative of her ability to pay?
That's certainly a very strong indicator that she was able to come up with a substantial sum. The total amount was $587,000. She'd already come up with $200,000, and she represented to the court in the in the statements regarding her ability to pay that she would sell the property that she had bought in North Carolina that she concedes came from the funds that she had stolen from the victim. The court was aware that that property had been purchased for at least $325,000.
This all goes to before the original plea, with which was under the probation sort of scheme, and
That's
so
exactly
had to
right.
be determined to be reasonable.
That's correct. Of course, that issue is rendered moot by the fact that that is no longer extant. The only extant restitution order
Was pursuant to the penal law.
That's correct, Your Honor.
Now, does it matter, or does it have an impact, the fact that the court undercut the people's offer to the defendant because the defendant agreed that she was going to pay restitution in order to get a favorable plea from the court?
Yes, Your Honor. As the court stated during the probation revocation proceeding, the only reason the court undercut the people and sentenced her to probation rather than the 4 to 12 years that the people were asking for in prison was because defendant had made these representations that she would be able to pay the restitution. And so with the understanding that she would be able to make the victim whole, the court sentenced her to a very lenient sentence. Unless there are any further questions, I ask that you affirm.
Thank you.
I'd just like to briefly address respondent's argument that Callahan undermines this court's multiple decisions stating that this sort of issue is non-waivable and does not require preservation. Callahan addressed a completely different species of claim, namely that the court there allegedly delegated too much of its responsibility to the probation department. It was not a case about the sufficiency of the record evidence, which is presumably why when this court confronted the exact argument in Masagli, it had no trouble disposing of it.
But counsel, can you address that aspect of the matter, that the defendant herself, in essence, bargained with the court and said, give me less than what the people offer and I will pay restitution? Isn't that what happened here?
I would slightly quibble with that characterization, Your Honor, but I think the larger point is that, again, Consalvo is very explicit that even when there is a bargain for disposition that includes restitution, and even when the defendant agrees to pay that amount of restitution, there still needs to be evidence, and that's because...
Yeah, but so you're really going to the record support. That's what the cases talk about, but there's record support here. She owned 2 houses. She admitted that she had the money. She said she would pay. She looked at the judge. The judge said it on the record, that she said she would pay the $587,000. She had 2 homes. She was going to sell one of them. I mean, so this is not someone where there is not record support that it was reasonable to believe that there was sufficient record support that she could pay that amount.
Well, I want to be clear, Your Honor, to distinguish between Ms. Poirot's ability to pay, which of course we have also raised, but also the record support as to what the complainant's loss amount was. And so, independent of her representations about whether or not she could pay, there still needs to be evidence as to what the total loss amount was. And for all the reasons we've laid out, there simply wasn't sufficient evidence of that here. And the court's obligation to assess the evidence...
There were 400 and something checks that the people had and that they discussed.
There's nothing in the record... Sorry, Your Honor.
Go ahead, go ahead.
There's nothing in the record to substantiate that. There's only an allegation from the prosecution, and I have not found a single case anywhere in this state that has ever upheld anything close to that as sufficient to uphold a restitution order.
Just one...
So the 400 forged checks that totaled over $587,000, you're saying that's not enough?
I'm saying that's not in the record, Your Honor.
Wasn't there something left for the prosecution and the defense counsel to work out in terms of the final figure that she owed before sentencing? And the court actually adjourned the case a number of times for them to come up with that final figure, and also imposed a condition that before she was sentenced to probation, she had to pay at least $200,000 of that amount. So whatever was discussed between the prosecution and the defense counsel was what was ultimately agreed to by the defendant and the court, that that's what the amount that she owed.
Again, Your Honor, even where the defendant explicitly agrees to pay a certain amount, and this is Soar, this is Masagli, this is Consalvo, that does not negate the court's independent obligation to ascertain whether there is evidence to support that loss amount. Would it have been better if this had all been worked out beforehand? No doubt, but the court's obligation was not fulfilled. There's not evidence in this record to support the restitution order that was imposed, and so it has to be vacated. If there are no further questions, we urge you to vacate the restitution order. Thank you.
Thank you. Pollock versus Cushman and Wakefield.
Good afternoon, may it please the court. My name is Mary Azaretto, and I represent the appellant Cushman and Wakefield. As a managing agent with no ownership interest in the property, in the absence of any affirmative negligence on its part, the only way that Cushman could be held liable for nonfeasance is if it was in complete and exclusive control of the property. Plaintiff doesn't argue that that's not the rule, or even that Cushman was in exclusive control of the property. Rather, they refer to an extraordinary amount of control. That's not the standard. And even if it was, all of the evidence in the record suggests that Cushman had little to no control over the property.
Wasn't
let
it
alone-
Cushman's responsibility to inspect the property and ensure that it didn't have any leaks or anything else, and then pass that information on to Verizon?
Cushman's responsibility for the premises involved engaging contractors pursuant to the directives of Verizon's upper management. They didn't have any independent duty to the plaintiff, such as that an owner or tenant would have. They're an independent contractor that's subject to an Espinal analysis. Based upon the well-settled case law in this case, a managing agent such as that needs to have exclusive control over the property in order for a duty to exist.
Well, counsel, what about the fact that the master service agreement in paragraph 2.9.12 provided that C&W, Cushman and Wakefield rather, was to maintain all of the repair and roof repair and all of those things. And how do you reconcile that with paragraph 20.9 of the same service agreement?
While the agreement does have a provision indicating that Cushman is responsible for arranging for repairs to the roof, that provision cannot be read in a vacuum. Paragraph 29 expressly limited Cushman's ability to enter into the contracts and provided Cushman may not bind Verizon without express authorization. When read together, the contract does not place exclusive control in Cushman's hands. In fact, plaintiff himself testified that he had been on the roof with contractors on various occasions. Thus, even arguably speaking, if Cushman did have a responsibility with regard to the roof, it certainly was not an exclusive responsibility, as plaintiff himself admitted. And without that exclusivity, a managing agent such as Cushman cannot be held liable in this case. Nor does the fact that Cushman had the ability to stop the work of any of its contractors change that result. Cushman's not an expert in roofing repairs. They're a managing agent. The fact that they had the ability to stop something if they saw it and it was dangerous is a far cry from establishing that they had exclusive control over the property. And I also want to point out, it's the entire property, not just the area where the incident allegedly occurred. So even if they did have exclusive control for the roof, that's not enough under the well-settled case law. We need exclusive control of the entire property. And every witness who testified in this case made clear that it was Verizon who had the final say with regard to all decisions. In fact, plaintiff himself testified that if Mr. Arizmendi of Cushman asked him to do something, he had no obligation whatsoever to do it. And that is a far cry from someone who has exclusive and complete control over the property. Unless there are any questions, I'll rest on my brief. Thank you.
Good afternoon. If it may please the court, Joseph Kazmachek of Kazmachek McGrath to the respondent.
Counsel, can I ask you, how do you satisfy that third prong of Espinal that counsel just spoke about, where the individual would have to have exclusive control, where here it seems like Verizon has completely displaced C&W based on the agreement? Specifically with regard to section 20.9 that's already been
The section 2.1112, I spoke about the court in the record on page 776. It gives them, shall provide all roof maintenance activities, including but not limiting to.
Right, that's true.
Right.
Then what is 20.9, I believe it is? How do you rectify that?
There are other areas where the Cushman Wakefield and the mechanical engineering and plumbing takes full responsibility in the contract here, in the documents, in the pages following. The service provider agreement, which was not attached to their motion, original motion, which was not attached to their court papers, is...
Counsel, 20.9 as my colleague has already referenced, says notwithstanding anything to the contrary set forth in the agreement, C&W has no authority to enter into any contracts or agreements of any kind on behalf of Verizon or otherwise. And then there is testimony from people who said that it wasn't the way it was. They were not the go-to people. So even in far as custom is concerned, it wasn't C&W that was supposed to take the lead on these cases.
This accident happened in 2013. This document was only signed in January 2013. The various witnesses produced had 20 years' experience. This was a new contract. They didn't do this before. The areas that they spoke about doing this, people 20 years ago.
This contract, you're saying, was signed in January 2013?
January 14, 2013, when this contract came into.
12
So
months.
that predates the accident, though, right? So
Right.
that is the contract that was in, the agreement that is in place at the time of the accident.
Yes,
So I'm not following your argument.
I'm talking about the people who talked about, they knew about what happened in the 90s or 20 years ago. This is not what happened. This contract.
Notwithstanding any of that, I mean, you really still haven't answered the question about 20.9. How do you reconcile that? Even if you're saying that Cushman & Wakefield was responsible for repairing the roof, how could they do that if they couldn't enter any contracts without Verizon giving them the authority to do so, where the contract explicitly says they cannot do that without Verizon's approval? How is that complete displacement?
Cushman & Wakefield's job is to work on the project. Cushman & Wakefield will get paid for all their services. Cushman & Wakefield could hire vendors and then be paid later by Verizon. Cushman & Wakefield was a qualified person here who could enter into these contracts in their own name and later on get applied. The contract, the documents give in the various sections that Cushman & Wakefield will be reimbursed for items paid out in the original master service agreement. I believe it's in the court record, in pages 615 and on, that they would get paid back. Cushman & Wakefield took this obligation to walk the premises, these 30 different projects, and to hire contractors. The two documents are completely at odds with each other. There were factual issues here as to what Cushman & Wakefield's responsibilities would be here. The record on page 800 is that Cushman & Wakefield will be the first line of eyes and ears of Verizon. They are the obligation to walk the property, and so did the witness testify that he walked this property and the other properties on the various times to look for things. The witness spoke about that he did hire a contractor to repair the roof. It is in the record on page, I believe, 412, that the greenery was growing through the roof, and that the documents, while here, give two different. Cushman & Wakefield was hired at this time to do this type of work. This was their expertise in what they did.
Counsel, even if you take everything you say as true, as opposing counsel mentioned, the requirement that there be an entire displacement, not some role. And even if you accept the things you're saying, that maybe is some role, it's not entirely displacing, even if all the things you say are correct.
The document itself on the first page says, takes all-inclusive property manager services. On the record, page 770, shall provide all-inclusive property manager services. The language is so encompassing right there. Thank you.
Thank you.
Respectfully, counsel doesn't dispute the rule that was set forth in regard to my main argument or dispute the fact that exclusive control can't be met. Walking the property and looking for things that require attention does not equal complete and exclusive control. That's the standard. That's the burden that Cushman & Wakefield met. Unless there are any questions, I'll rest on my brief. Thank you.
Jimenez versus PR Grand.
Good afternoon. Natasha Ayers on behalf of the appellant, Jay Jimenez.
Go ahead.
Sure. Your Honor, plaintiff's cross motion should have been granted for multiple reasons. This case started out with the defendants both making summary judgment motions. The expert for the elevator company's affidavit misstated the facts and stated conclusions that were not supported by the facts. For instance, its expert stated that, that there was no record that the safety edge, the electronic safety edge, ever malfunctioned. He also said that there was no record that anybody notified the elevator company of the plaintiff's accident or that anybody came out. And he relied on these facts in forming his opinions, among other opinions. And those facts were wrong. In the written record of the elevator company and the testimony of the elevator mechanic, Mr. Towers, he said that the safety edge, the electronic sensor, was intermittently malfunctioning. It was not only misaligning, but because it was malfunctioning and continued to malfunction, he was going to replace it, but never had at the time, by the time the accident happened. So where Mr. Halpern comes to the conclusion that there was nothing wrong with the safety edge because it's a foolproof design requiring no adjustments or no maintenance is false, because his own client made adjustments and continually made temporary repairs until—
Counsel, what you just said is, to me, is pitting one expert against another with issues that sound like they're factual issues, which is what the court seemed to conclude, that there were issues of fact here that needed to be resolved by a jury. Why isn't that still the case based on the argument you just made?
Because Mr. Towers is not the opposing expert. Mr. Towers is the mechanic who worked on the elevator at the company.
Well, it's still testimony that's conflicting.
Yes. However, Mr. Halpern based his opinions on the testimony, and he says there was no notice of anything being wrong with the safety edge.
And by the way, there are two experts in here who do give conflicting reports.
Actually, no, Your Honor, the plaintiff's expert, which is Michael
Mr. Sena, or Sena, yes.
Sena. He goes on in great detail that the reason why this happened was because of the operator and its rollers.
But he doesn't, but he says this sort of generally, doesn't specifically refer to the precise door. I think there are two doors and then maybe side doors as well. I mean, there's a back and a front door.
There's two doors. The plaintiff described the problem being with this front door repeatedly. The records, which the elevator is obligated under the law to maintain and describe, specifically refer to both the operator and the safety edge needing to be replaced. And by having the elevator company not make appropriate records and to describe which door and to give an elevator company credit for not doing its job in reporting is not what should be done here. The plaintiff described the chronic problems with the elevator. There's no testimony
Counsel, I want to ask you about Justice Douglas's preclusion order, because it seems to me you overstate what it says. Doesn't the preclusion order only say that defendants may not describe what's the content of the video? It doesn't prevent them from talking about the etiology, the causes of the accident.
First of all, the preclusion order only related to the hotel. And the hotel could not dispute the contents of the video. The contents of the video is the happening of the accident.
No, but that doesn't mean they get to say nothing. Or you're saying that they're not allowed to say anything about how the accident happened.
I said the hotel is not allowed to dispute how the plaintiff's testimony of how the accident happened. And the hotel's expert—
It doesn't say that in the preclusion order, counsel, with all due respect. I think that's a gross overstatement of what it says. Maybe you should go on to something else.
Well, the hotel's expert does not oppose the plaintiff's expert at all. He says they had notice of problems with the elevators. He doesn't discuss the operator. There's no affidavit put in opposition to Michael Sena's points that were not addressed at all in the initial affidavits by either Mr. Halpern and Mr. McPartland.
Thank you. You have rebuttal, so.
May it please the court, Chris Long for Litchfield Cavo for respondent P.S. Marcato, who is the elevator maintenance company. There is a second respondent, PR Grand Hotel, who is not here today. With respect to P.S. Marcato, it's our position as set forth in the papers that the judge got it right with regard to questions of fact on plaintiff's cross motion. Specifically, there is no evidence, testimony, or records demonstrating that the elevator doors ever closed too fast or too quickly. And there is no proof offered that the subject
Could you pick up the thread that your opponent talked about, that your experts do not dispute the plaintiff's expert concerning causation?
So we moved first, and our expert supported our motion. Their expert was in opposition to our expert. By definition, they oppose each other.
So does your expert ever say that it was not the two parts of the elevator that Mr. Sena identifies?
No. Our expert opines that the elevator was properly maintained, which is at odds with what Mr. Sena finds.
Doesn't that go to more to notice than to causation?
Sure, and there is no notice here, Your Honor, both actual or constructive. And additionally, in the appeal, plaintiff appellant, talks about Marcato creating the condition with the repair work that it did, and that's just simply not the case. That is belied by plaintiff's own testimony that on the date of the accident occurred at the end of the day when he was on his way to clock out. He rode the elevator multiple times, 4 or 5 times without any issue, and then when he did chance upon it on his way out the door, and it was ajar, not opening fast enough, that's when he forced the elevator open, shimmied his body in between the door and the elevator frame, attempted to force it further open, and at which point he alleges that it forcibly closed upon him, pinning his knee. That is not Marcato creating the condition, Your Honor. Rather, that is plaintiff creating the condition. Additionally, with regard to the spoliation, the plaintiff filed a note of issue and said that there were no issues with discovery. 2 years later is when this elevator inspection happened, and they allege that this safety edge that appears in the photographs at the site inspection was surreptitiously removed and replaced. But as set forth in the motion below and appreciated by the lower court judge, that's simply just rank speculation. There's no evidence at all that the safety edge that was visible and was there at the time of the inspection was even the same safety edge that was in place on February 14th, 2016. If there are no questions from the panel, I'll rest on the papers. Thank you.
Thank you.
In response, Mr. Halpern, the expert for P.S. Marcato, never mentioned or counter-argued or made any opinions whatsoever, and not even mentioned the operator in his initial affidavit. The responsive affidavit by Mr. Sena discussed at length how it was the operator which malfunctioned, which is noted in the records that needed to be replaced, that caused the door to shut. The safety edge, which is the electronic eye, could intermittently malfunction, but even if it was functioning, even if you believe Mr. Halpern's opinion that it is a fail-proof design, if the operator is broken or intermittently malfunction, it cannot pick up the signals from a properly functioning safety edge. And therefore, the safety edge would have irrelevant to the happening of the accident. This operator and the rollers, which are completely documented, repeatedly being broken in the records, were not addressed at all by either expert for P.S. Marcato or for the hotel. Not even mentioned, not discussed at all. And that is why I argued that plaintiff's cross motion should have been granted. And also related to the other issues of the spoliation, I had to file a motion to get the post-accident repair records. It took me a long time to get it in the Bronx. I get it, then I get a decision that I win, they have to give me the records. The response by them was, we don't have it, we don't have the records, period. So I filed the note of issue based on their affirmative statement in response to the court order that they do not have the records. I can't make them produce something they spoliated and gotten rid of. And that's why I said that their answer should have been stricken. In keeping with what happened in the inspection, the day we get there, come on, you're going to remove the safety edge right there in front of our face? And they're yelling at me to not take pictures? And that's the reason
Can you
why.
respond to your opponent's point that the safety edge may not have been the safety edge that was there on the day of the accident? We don't know that.
It would have been very easy for them to prove that, right? They could have had a work order or invoice, an affidavit from somebody saying, this was not the same.
Is that their burden to do so, though?
Well, if I'm saying something in my cross motion, yes.
Yeah, but what, on the basis of what are you saying that thing? In other words, do
Because
they have
there's
to
no
respond?
record, and in the deposition testimony, the witness stated that it had not been replaced. The operator had not been replaced. I understand your point, Your Honor, but here we have a situation where we're going to inspect it. Why remove it? Why remove it the day of the inspection when the elevator is shut down? The minute we get there, it's sitting there in the pictures next to the door.
Thank you.
Without explanation.
Thank you. Thank you both. People versus Yellington Concepcion.
Good afternoon. Legal aid by Lorraine Modello, appearing for Mr. Concepcion. Mr. Concepcion's guilty plea was not voluntary, knowing, and intelligent when the court led him to believe that he was receiving the minimum incarceratory sentence by his plea of guilty.
But wasn't he receiving, wasn't, as the judge said, 2 years in prison? Didn't the judge make clear that that was an incarceratory period? That was the minimum, the agreed upon period was the minimum incarceratory period?
It wasn't the minimum incarceratory period, though. That's what the...
But that's because, well, which...
Because it was a D violent, it was his first felony conviction, it was a felony sex offense.
But counsel, are you disputing that if he got prison time, 2 years was the minimum prison time? So it was the minimum prison time?
No.
What?
No, the question, it's not the
No,
minimum.
what the judge said was you get the minimum prison time.
Okay, yes.
So why doesn't that mean the minimum time if you are going to serve a prison sentence? Why isn't that clear?
It's not the minimum incarceratory, possible incarceratory sentence.
You said prison, though.
It's the minimum time if he were sentenced to state prison. He couldn't have gotten a state prison sentence of 1 year. He had to get 2 years if he went to state prison. But other possible, he could have received a sentence.
But she didn't say you got the minimum sentence. She said you get the minimum prison time.
Yes, and he's 20 years old with a very minimal contact with the criminal justice system. And
You're saying he could have not just been in the state time, he could have gotten city time,
Yes,
which would have been less than the 2 years.
It would have been less than a year.
Less than a year.
And to ask a 20-year-old who has no criminal legal background to understand that a city jail is jail time and state time is prison time, that's not realistic. The court mistakenly led him to believe that if he lost a trial, he'd get the minimum prison time of 2 years, and that was not correct. That led him to plead guilty and enter a plea that was not knowing, voluntary, and intelligent.
Counsel, is there any view that we can take of the totality of the circumstances, given the strength of the people's case, and the promise of the promised sentence was reasonable, that maybe, and the fact that it wasn't raised by his counsel at the time of the plea or the sentence, this particular issue? Is there any way that we should be viewing that?
Those are two questions.
Yes,
right?
I know.
Yes. It wasn't raised by counsel, but we would submit, we do believe that it fits into the Lori exception set forth by the Court of Appeals. Mr. Concepcion, again, he's 20 years old. He's barely been in contact with the criminal legal system, and a judge who is empowered and obligated to make sure that any guilty plea is knowing, intelligent, and voluntary. That's why she asks all the questions about, are you giving up your right to trial, all of that, says to him, this is the minimum prison time. So we would submit that it does meet the Lori exception, that it does not require preservation. In terms of, I think you're asking, what would his likely sentence have been if he had gone to trial? That is unclear, and I don't think it's anywhere near that he would get 2 years in prison. He had one assault 3 conviction, and at that time, okay, now it wouldn't count, but one marijuana conviction. He was 20 years old. This was, he had less than a high school education. There's not any kind of indication that a court would automatically sentence him to state prison. Many courts would say, you know what, I have the option of 10 years felony probation where he can be watched, where he can be supervised. That's a real possibility in a case like this. That's why in those felony sex offenses, they allow for such a long period of probation. He could have gotten a city jail sentence. So it's not highly probable. It's not even probable at all that if he went to trial, he would get a state prison sentence, which further makes the point that a court telling him that that's what you would get shows that his plea was not knowing, voluntary, and intelligent.
Thank you.
Good afternoon. May it please the court. David Gagne for the people. The defendant did not preserve
Counsel?
his claim regarding the
Counsel?
voluntariness.
A question. Did he have a lawyer present when he took the plea?
Yes, Your Honor.
Okay. Is the judge required by law to tell him at the time he's taken the plea every single ramification of whatever term of incarceration or probation he's entitled to?
No, Your Honor. There is no such requirement.
Okay.
And just to be clear, the record does make it very explicit that the defendant had already agreed to plead guilty to a 2-year prison sentence.
This was a negotiated plea deal, you mean?
That's correct, Your Honor. The defense counsel at the beginning of the plea proceeding stated, Your Honor, we have a disposition. My defendant agrees to plead guilty in exchange for 2 years in prison and 3 years of PRS.
So this was not a negotiation with the court. This was between the prosecution and defense counsel.
That's correct, Your Honor. And the court's statement, just to be very clear, was entirely correct, that he was receiving the minimum prison time allowed by law. That was an entirely correct statement, and so there's really no way that the defendant could have been misled and that his plea could not have been voluntary.
This was a legal issue, so it's one that the attorney, I mean, sometimes we say, well, there was no way the defendant would know, but his attorney would have known, his attorney would have heard, and his attorney would have been able to make the objection or ask at sentencing to take back the plea. That would have been able to be done.
That's entirely correct, Your Honor. And that's exactly what this court said in People v. Melendez, where purported misstatements regarding a defendant's sentencing exposure do require preservation, because even if the defendant, him or herself, were not aware, then certainly their counsel should be aware of the possible sentences. Unless there are any further questions, I ask that you affirm and that you waive the surcharges and fees. Thank you.
Thank you.
If I may.
Sure.
The judge is not required to set forth the whole possible range of sentence when someone pleads guilty, but a judge is required not to mislead a defendant. And that's what happens here when she says...
What is the defense counsel there for?
I'm sorry?
What is the defense counsel doing there at the time that the plea is
Defense counsel has obligations, but no matter what the defense counsel's obligations are, the court has obligations. Otherwise, every time someone came in and said, my client's offering to plead guilty, And then it would be, okay, fine, and everyone would walk out. But
There's no question that you're correct. There's no question that you're correct about the court. Obviously, the court wants to get it right every time. But in this case, the question is whether that is reversible error, where the court is perfectly accurate, given that this is a negotiated plea and that counsel is standing there, and it's the kind of case that requires preservation. The court wants to get it right all the time. You said yourself, I think the court, you said mistake, but it wasn't a mistake because it was technically correct.
Yes, yes, it was misleading, yes, because it's state prison. Yes, but this is the type that does allow for an exception. It doesn't require preservation. If not, we would ask this court, if this court finds it doesn't meet the exception, we would ask this court to use its interest of justice power, because what you have here is a 20-year-old, a kid, pleading guilty because a judge has told him, if you don't plead guilty to this felony sex crime and you go to trial and lose, you are going to prison for 2 years. That's the minimum I can give you.
I think we understand the issue. Thank you very much. Thank you both. Hamway versus Sutton.
Good afternoon. My name is Adam Peskin. I represent the appellant, Isaac Sutton, who's one of many judgment debtors with respect to the underlying case. This was a supplementary proceeding in which the judgment creditors sought to restrain.
Counsel, how are we supposed to read, and what is the interplay, if you will, between insurance law and the CPLR with regard to that? Are we supposed to be looking at this $18,000 monthly amount that your client receives and take 10% off pursuant to the CPLR that seems to be more specific? Or are we supposed to take $400 of that out and then take 10% off of the remaining?
That's correct.
$1,760?
Correct, Your Honor.
Or are we supposed to look at it as, well, you already, why don't you?
Yes, Your Honor. The latter is, I believe what is accurate, is that there's an exemption, the $400 exemption, and that becomes part of the estate, which then is subject to the wage garnishment protection that's afforded all New Yorkers. The whole purpose of wage garnishment protection is to avoid a bankruptcy. In fact, if it was the case that wage garnishment didn't apply to disability,
Counsel?
Yes.
What about the second sentence of CPLR 5231C, which says nothing in this section shall be construed to modify, abrogate, impair, or affect any exemption from the satisfaction of a money judgment otherwise granted by law? What's your understanding of that sentence and how that interplays with the insurance law provision?
Correct. Your Honor, my understanding is that essentially means that they're read separately. They're not incongruent, they're just read separately.
Doesn't it say nothing in this section, meaning 5231, shall modify or impair any exemption? And isn't what you're arguing that CPLR 5231 does modify the exemption in insurance law 3212?
But actually it doesn't. If you look at the insurance law 3212, it talks about the exemption. The general rule under 3212, and I will admit it is convoluted, no question about it. It could have been read, it could have been drafted a little bit more clear. But the general rule under 3212 is that all disability payments are exempt. That's the general rule. It then, in the next sentence in 32122, it talks about the $400 monthly exemption and that it's limited to the exemption. The exemption is limited to $400. The exemption being the exemption, the general exemption under 3212.
You're saying that you can't affect all that sentence means is that you can't affect the $400 exemption.
Correct. Correct. I mean, the garnishment rules, the garnishment protection, wage garnishment protection under New York, the purpose is to avoid a essentially the purpose, the underlying purpose is to avoid a bankruptcy. Under the bankruptcy code, whether it's Social Security disability, whether it's private disability, it's all exempt. So essentially what you're telling the judgment debtor is just file bankruptcy and just avoid all of this. But that's not the point of the wage garnishment protection laws. That's why we have them, so people could live. The legislator didn't intend, I would submit, the insurance department didn't intend for people that are only earning, essentially can only be living on $400 a month. That's just preposterous. That obviously was a supplement. It was set as the floor. It was set as the floor, and as you point out, and just getting back to that, the limitation of the $400 exemption relates to the general full exemption under the proceeds, the full exemption of the proceeds. So I don't see how it's incongruent. We did cite a case that was in dicta, the Guttenspan case, that talks about how it would play out. The way it would play out is you would be entitled to your $400 exemption, and then the applicability of Article 52, which is ubiquitous. I mean, that is the standard. That is what that's what the sheriffs follow. That's it. So I think it's pretty clear how it should play out. I can't see any reason, public policy-wise, why the disabled person who's receiving a wage supplement is entitled to less protection than any other New Yorker. That makes absolutely no sense. And I will reiterate that Article 5231 says all money from all sources. There's no carved out exception that makes any reference to insurance law. Unlike matrimonial, domestic relations law, there are exceptions that play in there that they acknowledge.
Counsel, if we try to do the calculation, you said in your brief that it was a $19,000.
Correct.
Is that a mistake?
No, it was. I believe it's $19,000
per month.
Per month, right? Correct. I believe that's it.
So it's not 18,000?
I believe it's
19,000.
My understanding is it's 19,000.
So the 400 would come off of the 19,000 for an 18.6.
Correct.
It would be 10% of 18.6.
Correct. And I would just want to note, and I don't want to forget about this, is that there had been a stay that was imposed by this court, and then it was lifted. And in light of lifting that stay, my understanding is $157,040 has been issued to the judgment creditors. However, I don't know if they received it yet. We would only ask if it is reversed, if it is modified on appeal, that there be an order directing the return of 90% of the $150,000 payment to the judgment creditors. Thank you. Any questions?
You have rebuttal, don't you?
Okay, yes. Thank you, Your Honor.
Good afternoon, Your Honor. Stephen Storch for the respondent. One assumption that's being made here, and it's just not supported anywhere in the record or in the law, is that disability payments are somehow the equivalent of wages or some sort of wage supplement. They don't cite a single case for that. We cited a federal court case in the disability arena where the court, in the case we cited, expressly said that disability payments are in fact not substitutes for wages. So they make that giant leap and then say that the CPLR applies when the provision they point to is clearly talking about wage garnishments, earnings, and that sort of thing. That's not what this is.
So are you saying that the phrasing in 5231 from any source is limited by the following words in income execution?
Correct. It goes on to talk about, it's clearly aimed at wages and earnings. That's what this provision is aimed at. Now, the insurance provision, is a very detailed. The insurance department, when it analyzed it some 20 years ago and came out with its informal opinion that it means exactly what the respondent says it means, the insurance provision is very specific. It says, with respect to all other debts or liabilities incurred after the commencement of disability, this is a debt that incurred after the commencement of liability. The exemption of income payment benefits payable as a result of any disability of the insured shall not at any time exceed payment at a rate of $400 a month for the period of such disability. You can't get more explicit than that. The exemption cannot be more than $400. What they're asking this court now to do is say, oh no, ignore that language, and on the $18,000 or $19,000 on the monthly payment, they only get a percentage, 10% of that amount. That would completely eviscerate the insurance statute. And by the way, there's nothing against public policy about this. We're talking about debts that the allegedly disabled person incurs after the disability. First of all, this is not a sympathetic judgment debtor. He has defrauded multiple people. He has multiple judgments against him for acts done after the disability commenced.
Counsel, does either of the statutes contain anything about sympathetic versus unsympathetic judgment debtors?
No, but I'm talking about the public policy, because counsel did say...
I know, but the public policy has to apply to the entire public, not just to this defendant.
Right. And I think that the insurance department is, or the legislature said, look, somebody gets disabled, they go on disability, they go out and they buy a Lamborghini, and then they default on the payments. We're not going to say, hey, you can't go over after the disability payments because they're exempt under the statute, giving any person collecting a policy basically free rein to not pay his bills, and then say all my payments under the disability policy are exempt.
Are you simply saying that the insurance law does not apply here at all? It just doesn't apply?
No, I'm saying the insurance law absolutely applies. The insurance law says you can exempt $400, and the rest of it is subject to execution. It couldn't be any clearer.
You're saying the CPLR shouldn't apply.
The CPL does not apply by the language that Your Honor cited, that last provision that says nothing in the CPLR is going to affect or modify an exemption.
You're saying we don't even get to that provision. You're saying that income execution only refers to income and that disability payments are not income.
That's right. Disability payments are covered.
And there's a federal case that supports that.
I'm sorry?
Are there any state cases that support that analysis? I know you mentioned the federal case.
Only the insurance department opinion, which is not a case, and I understand that's not, a court decision, but they are entitled to deference as an administrative agency. But I think the statutes are very clear. The insurance law is very clear that he's entitled to a 400 exemption, and that's it. And the CPLR is saying nothing in the CPLR is going to affect or modify any exemptions provided under law. I don't think it could be more clear. If there are no questions, we'll rest on our brief.
Thank you.
Thank you, Your Honors.
Your Honors, there's nothing in the record that would suggest that this, in fact, as a matter of fact...
What about that specific question or argument made by counsel that disability payments are not subject to CPLR 5231 in the first instance, they're not income to which the statute would apply?
Judge, there's not a hint of that in the CPLR Article 52. Article 52 is the bedrock for judgment enforcement. This is what the sheriffs look to. This is, I mean, to say
usually
now...
when you come across a 5231 case,
Right.
it is about wages. All the 5231 cases I've seen have always been about wages.
Correct.
And clearly wages. So
Correct.
what's the, just that he didn't sign any cases, what's the authority for saying that that language should be included to include disability payments as opposed to regular wages that you go out and earn?
I mean, if you just read the statute, it says money from any source. Money from any source. That's as broad as you can get. That doesn't say income, doesn't say wages. It says money received from any source. You can't get any broader than that. That includes everything. That includes rental income, anything you want. Here is a wage.
So
It
then the
happens to be a
following,
wage.
excuse me, the following sentence, after the apostrophe, after the comma rather, it goes on to say income execution. Is that not qualifying source, any source? The fact that it says income execution, and then we would have to determine what is income, right? It's,
Well, Your Honor, I mean, we would submit it is income. Yeah, I mean, it is income from any source, whether you want to call it, but it is as broad as you can get, and I can't see how this court.
Did the tax law come in any way here? It's not discussed in the briefs, but I mean, in other words, are disability payments taxable? If you know.
Judge, I do believe they do receive a 1099, so it is reported. My understanding, it is not taxable, but it is reported, I believe, on your 1040. It would be reported as, because he does, my understanding is it receives a 1099, but it may be checked off as exempt, it's disability. That's my understanding. A limited understanding from the tax law, which is nothing to brag about, but that is my understanding. I don't think that was part of the record, though.
Thank you.
Thank you, Your Honor.
Contreras versus MDG Design.
Good afternoon, Your Honors. May it please the Court. Brian Isaac, I represent the plaintiff appellant in this matter. Simply put, I don't think there's any question in our view that this is an absolute labor law violation. There's no question that the roof ceiling of this building collapsed. There are photographs depict it. One of the photographs that the defendant relies on shows one of my clients buried in ceiling debris.
Counsel, I think the issue here might be foreseeability. Do you want to address that?
Sure, so let me deal with that. And that, I agree, that is the issue. And my argument on that, Judge Pitt, is simply this. Negligence foreseeability is not the same thing as labor law foreseeability. In fact, I learned the hard way in Jones against 414 Equities, which is the case that I lost. And
Let me just ask a question related to that.
Sure.
Which is that there seems to be a different standard for ceilings falling even within the context of 240 cases, that it does bring in a foreseeability standard that's not generally present in 240 cases, but it seems to have developed in the context of ceiling cases. This is an addendum to a question, that there does seem to be a foreseeability requirement built into the case, so that's not built into other 240 cases.
Right. So I think, Your Honor, what you're talking about is you're talking about foreseeability, for example, with respect to ladders, scaffolds, things like that. When they fall, you don't have to show that they're defective. But I'm relying on 3 cases that I want you to look on, all from you, okay? And the cases are Mena against 485 7th Avenue Associates, it's 199 AD3 D420. A case called Sinchi, S-I-N-C-H-I, against HWA 1290 3rd LLC at 184 AD3 D408. And the last case is a case called Diaz, D-I-A-Z, against HHC-TS REIT. Every one of those cases involved the exact issues that both of Your Honors were talking about. The defendants claimed in those cases that the objects that fell during demolition were not foreseeable. And my reading of those cases, one of which is mine, Sinchi's mine, is that this court said that when you're engaged in demolition operations, you have to secure things that could fall.
But those aren't ceiling cases.
Yes, Mena is an absolute ceiling case. Sinchi is an absolute ceiling case, and Diaz is not a ceiling case. It's a case where the plaintiff was trying to pull a 2x4 out of a building column, and a pole or a device that nobody knew was there. That's in the decision, that nobody knew that came out and struck him. So the point I'm making here is, and apropos to your questions, remember, my client's testimony was that in every single other construction that they did, there was demolition already done. There was no ceiling, and all they did was put on the window. Here, there was no demolition done, and my clients became de facto demolition workers because they had to remove both the window, they had to remove the molding, and they had to remove the surrounding structures. In those situations, I think you have an obligation to secure that which can fall. Also, let's not forget about the other evidence. The building department, right, not my client, came to the scene of the accident, 270 of the record. This is what the building department inspector said,
Well,
and I'm
let me
quoting.
go back, though. Don't you still have to, and part of the problem is this case is so early on, in terms of the summary judgment motion, it's not typical. Normally, there's more discovery before someone moves for summary judgment. Isn't part of what you have to show that the owner had some understanding that this demolition work would cause the thing to fall? It's not enough to just say a ceiling fell and therefore you have a 240 case. There's something more you have to establish to show that there's liability.
I don't disagree with the generalities.
What
but-
about that something more? Is the record developed enough in this particular case where discovery really has not taken place to show that something more, as opposed to letting some discovery take place and then renewing the motion if the evidence is there?
Well, the answer to that question is generically yes, but I think specifically, Judge Kern, no. And here's why. I've got the other evidence. I've got the plaintiff's testimony that this apartment was very old, over 100 years old.
But very old is not,
No,
is not enough by itself.
Agreed, but
You wouldn't be able to say it fell and it was very old and therefore I made out my case.
100%.
Well, the
What's
fact that,
something else?
sorry, the fact that they had demolished other apartments before putting in windows, and then in this particular one, I mean, that was obviously done for a reason. And then in this particular one, that didn't happen, and the ceiling fell.
Correct, and that was one of the...
I mean, can we look at it like that way?
Sure, but I've got two other pieces of evidence that I just want to bring to the court's attention, and I won't go over my time, I promise. It's 270 of the record. This is the bill...
I think you already went over your time, but I will allow you 30 seconds.
If you let me do it, I'll be done in 30 seconds. 270 of the record is the building department's post-inspection, where they specifically say that there's a violation because the apartment 5W, the ceiling in the room at exposure number 1 was poorly maintained. Poor maintenance is patent, and even if you look at...
You're saying as a matter of law, we should say that the fact that it said it was poorly maintained is enough as a matter of law without any discovery to give them notice that the ceiling would fall down if they took out the window?
It's not only that, it's their own report. You know what, I'll finish this up in my reply, Judge Kern. I'll remember where it is and I'll get right to it, I promise.
Good afternoon, may it please the court. Patrick Thompson from Baxter and Smith for Respondent Uptown 6 LLC, the owner of the property. There's 2 other respondents who aren't present today. I just want to touch on some questions that were brought up. The Dob violations, they were the ceiling had already collapsed. It was inspected after the ceiling had collapsed. The Dob does not know what the ceiling looked like before the incident occurred. This is a premature motion. We just did depositions a couple.
Well, counsel, I mean, I guess I'll ask you the same question. In other apartments, it was demolished before these gentlemen went in and put in the windows. And in this particular building, in this particular apartment, that didn't happen. And then the ceiling collapsed. Isn't there a reasonable view that there was a reason why it was demolished beforehand, and here we are now with a ceiling collapse? Why wasn't there some sort of foreseeability there?
It's a valid question. I represent the owner, not the general contractor. They're not here. We didn't get to depose the general contractor yet about their inspections, the timing of their work, why they did this. Also, there was multiple buildings, and I deposed the plaintiff, so I don't want to bring in information that's not in the record, but they worked in a different building before this, before they worked in this building. But also, they provided an affidavit, a 2-page affidavit. It's a foreseeability argument, right? The only thing they say is the room was old. That doesn't mean that there was cracks in the ceiling. That doesn't mean there was water damage in the ceiling. So it's about foreseeability here, and they haven't provided any evidence that this was a foreseeable risk to remove a window on a wall that wasn't touching the ceiling. There's no evidence here regarding foreseeability. And that's really the crux of the argument. But we haven't had a chance to depose all the parties. We haven't had a chance to depose their foreman. There was paper discovery that was served afterwards that had photos of the room before the incident occurred. So the motion was premature, and that's pretty much it. Any other questions? Thank you.
So Judge Kern, to get back to you so I don't forget, I'm asking you to look at page 928 of the record and 930 of the record. This is the defendant's non-affirmed report where the defendant, this isn't the plaintiff, says The entire ceiling collapsed as a result of nail stripping and no longer supporting the existing wood ceiling framing with original 1-inch thick plaster finish. And on 9/30, showing a photograph, their expert, not mine, says that it is visible, use the words visible, that the nails of the wood support system for the existing ceiling frame failed. My point isn't that there is no discovery. They're in a better position than I am to talk about what happened because it's their building. I have 2 construction workers. They don't know anything about the building. They're putting in windows. The general contractor put in a brief. The managing agent put in a brief. The owner put in a brief. What particular fact is there to discover? They have all the facts in their possession, and they're saying that because they didn't conduct depositions, it's premature. You just rejected that argument in the case Laporta, which is cited, not even cited by my adversary, where you said that depositions are not required. The fact of the matter is that if you look at your Mena decision, it's almost on all fours with the case at bar. In that case, the plaintiff was chipping a hammer to remove part of a wall directly adjacent to the ceiling when a concrete slab, not the whole ceiling, a concrete slab fell from the ceiling and collapsed on him. And this is what you said, your words, not mine. Photographs of the accident site show that the wall plaintiff was removing with the chipping hammer was directly adjacent to the slab that collapsed and fell on him. The photographs also show that the entire area, including the ceiling, appears to be in partially demolished condition. This is completely demolished condition, and is reasonable to believe that plaintiff's work would create that collapse. And this court also held that the collapse was, quote, foreseeable as a matter of law. I ask you to follow that decision. Thank you.
People versus Michael Usenko.
May it please the court, my name is Anthony J. Collery for defendant Appellate Michael Usenko. I'm given the previous warning of the clerk and after save some time, I'm going to focus basically on the first portion of my brief. That is the part about the case law, about the case rather being not in English, basically. I remember my 4th grade teacher, Ms. Brody, teaching us that a sentence begins with or has a noun, and the noun is acted upon by a verb. In this case, the action is emission and the noun is ejaculate, and that's the rule. And the court chose to take make an idiom out of ejaculation, emission of ejaculate, as opposed to one being a verb and the other being a noun. They use the thing as an entire, basically an entire noun. The people argue that that's fine, that you can do that, it's not an issue, but they then also argue that they were entitled to the presumption that the ejaculation was for the defendant's pleasure, sexual gratification, if you will. And that only comes if you have a situation where there is a defendant ejaculating on top of a body, which is what the whole statute's about. That is the reason why that's there. It's not about something that happened before and happens later. In fact, we don't even know. If that's the case, they haven't even proven that the ejaculate wound up there through masturbation or by the defendant's own masturbation or by anything that had to do with the defendant or the victim. It could have been done by a third party. It could have been done by a dominatrix. There's 1,000 ways it could have been done other than through his own masturbation for his own sexual pleasure. And so the result of that is they wanted their cake and eat it too.
You either have the argument that there was an emission at the time, and then therefore I don't have to prove that there was a.
But was there any attempt to alter their charge by making a request to charge that captured some of the concepts that you're talking about now?
I believe there was a conversation about that, Your Honor. I believe that the defense counsel said, but the record is not really clear. He goes along when she says she's going to change the word from ejaculate to semen. He goes, all right, that's great. But I don't think anybody dealt with the argument that the emission, I don't think he saw it that she was taking away the verb. I think he saw it that the verb was still there, and now we were going to be more specific as to what this ejaculate was.
Well, counsel, let me just ask you this question, because it's my understanding that on the sexual gratification part, the conduct itself is what we can use to infer that there was sexual gratification. The fact that someone is putting semen on another person, we can infer that that was because of sexual gratification. But are you asking us to say that emission, which obviously involves ejaculate, because it was put in a cup, as opposed to just the way it would, I guess, normally come out, is not going to be for sexual gratification?
Their position was that the ejaculation was the portion that gave a sexual gratification, not the tossing it onto the person. And that's the problem with that, is that if it was the case of you can't have gratification in both, I guess you can have gratification in both places, but that you can't have a continual presumption that you had gratification in both places. The gratification, the argument was in the emission of the ejaculate into a cup. And then what he did with it after that was put it on her body.
But that lacks any other innocent explanation for that conduct other than, you know what, I'll withdraw. I
think what the court is trying to say is that it's like it would be part of a continuous motion, but it's not. The cases, and even Danino notices that, the cases are meant to stop someone from standing over another person in a position of power where the other person is knocked out and masturbating on them. Right? And the fact
I don't know that there's anything that the person has to be knocked out. I think the idea is ejaculating on a person, clothes, body, something of that nature.
Ejaculate, that's correct, Your Honor. Ejaculating on the person, not ejaculating outside of that, and then throwing it on the person. That is correct, Your Honor. That's what the statute's about. Ejaculating on.
But was this preserved sufficiently here?
I believe it was, but even if it wasn't, Your Honor, in the interest of justice, the court would have the right to look at this. This came in as a C felony sexual or D felony sexual abuse and was knocked out by the grand jury to a B misdemeanor. That's why he received a full jury. I believe in the interest of justice you can look at it, but I also believe it's preserved by his comments, both in the motions he made and throughout the trial as to what he was trying to prove or disprove.
Thank you. You have rebuttal, so you can remain there. Counsel, you have rebuttal, so you can remain there. Hello? Counsel?
Yes.
Sir. You have rebuttal. You have rebuttal, yes. So you can remain there.
Oh, thank you.
Yeah.
Good afternoon, Elizabeth Schmidt for the people. May it please the court. To begin, defendant's claim that he raises now is totally unpreserved. At the charge conference, defendant never asked the court to charge that the people needed to prove his direct ejaculation onto the victim, nor did he ask the court to instruct the jury that throwing semen did not constitute sexual contact within the meaning of the penal law.
But you do acknowledge, I think, that the scenarios that were discussed in the bill jacket involved direct ejaculation onto a victim.
Yes.
Nobody's disputing that.
No, Your Honor.
The question is whether at the time of trial, this was raised by the defendant.
That's correct, Your Honor.
Okay.
It was never raised at trial. Beyond that, however, Your Honor.
So should we be looking at this in the interest of justice, since this is something that everyone agrees was supposed to have been understood a different way?
No, Your Honor, we do not believe that this should have been understood a different way. The language of the statute is broad, and it encapsulates, or rather, it covers the defendant's conduct. He did emit his own ejaculate onto the victim.
But there's also an element that one or both of the parties have to be gratifying a sexual desire, right? Which is clear if the ejaculate comes directly from the defendant's penis, but it's not so clear if he's in a cup. I mean, I don't know what it means, but the inference of sexual gratification is not as clear. I think you'd have to concede if the ejaculate is in a cup as opposed to coming directly from the defendant.
Your Honor, I believe under all circumstances, his sexual gratification was very clear. To begin, this was a victim.
Couldn't it have been that he didn't like the woman? I mean, I know he talked to her and said, oh, nice dress, like it when you wear nice dresses. But couldn't it mean that maybe because she never responded to him, he was rebuffed and was doing something to annoy her?
So, first of all, the victim, and at no point during trial did it ever come out that the defendant was anything other than pleasant and complimentary towards the victim. There was no evidence put out that he was anything other than thoroughly interested in her. She was also wearing a skirt, which he had told her repeatedly was his preferred look on her on the day that he threw his ejaculate on her. In addition,
that what the act could be mean as well as it could be, I mean, I don't know that that's the first thing someone would think of, that it was sexual gratification as opposed to something that was disgusting and mean.
Your Honor, I disagree. I frankly don't really know whatever purpose you could have for throwing your own seminal fluid on a woman who you had expressed interest in.
Well, let me ask you this other question, just in terms of this word emission, right? If it was to mean something other than directly coming from the individual's body, they could have used another word like deposit or transfer or something like that, but they specifically included in the statute emission. Why aren't we limited by the normal understanding of that term?
I believe the normal understanding of that term is to emit, to give off, to toss, and that is what the defendant did here. He snuck up behind her with a cup of his own semen and threw that at her. And again, that's assumably a very sexually motivated act. You can even see in the video that was presented at trial.
I don't know where I've ever seen the use of the word ejaculation with regard to semen, meaning to toss at somebody.
Excuse me, do you mean emission, Your Honor?
Well, I think the question was just asked, maybe I'm wrong, but you said that's what it means to ejaculate, is to toss, to throw. I don't think I've ever seen the use of the word ejaculation in the context of semen as being to throw.
Your Honor,
or to toss.
The statutory term is the emission of ejaculate. So it's the people's position that the emission here is the defendant's throwing. The ejaculate is the seminal fluid that he threw. Yes, if you followed.
Yes, no, I follow.
Okay, just making sure we're on the same page. Thank you. Yes, so the defendant unquestionably committed this, and his acts totally fulfilled the statute at issue here. So if there are no further questions.
I have a question. Had the defendant and the victim seen each other on that day before this incident occurred?
I do not believe so, Your Honor. I may be mistaken. She bumped into him in the hallway afterwards on her way to see a police officer. I'm not sure if she saw him earlier that day. They did see each other very regularly as they both worked in the building and were either on the same floor or were separated by one floor.
But to be clear, this was not preserved, this issue?
Not preserved, Your Honor.
Thank you.
Thank you.
To get back to your question, there's no evidence in the record saying you saw her that day, which goes back to a whole other issue, which is how he would even know she would be where she was at the time she was there, and how would he get this cold ejaculate from the refrigerator or wherever. In addition to that, I just want to correct one other thing, and that is there was no testimony that what was in his hand was a cup or anything like that. The testimony was it was a black object. And so it's important the court remember that. Finally, the statute was not explained to the jury that the ejaculation was the tossing of the semen.
But that's something that also, I believe, was not preserved, because the defense attorney requested, in essence, that the court provide the CJI charge and provide the definition of sexual contact that is contained in the penal law.
Right, but the court also explained that it could use the emission of ejaculate not as the chief judge suggested here, the presiding judge suggested here. Never seen the word emission and ejaculate used in a way that where you would say it was tossed at somebody. So when you're reading the statute and you're reading it with a normal head rather than one trying to prosecute or defend someone, emission of ejaculate comes out to, yeah, it has to come out of his penis at the time.
But no one requested that the court define emission for the jury. No one did, not the prosecution and not the defense.
This is a justice somebody should have, because the statute should have come up with that.
Well, what she did was she read the CJI, the charge exactly as it is written in the CJI. And she read the definition of sexual contact exactly as it appears in the penal law.
But if she did that and she allowed them to then allowed them the presumption that whatever he did was for his sexual.
There were two notes sent by the jury. They wanted to hear again about sexual contact on 2 occasions. And on none of those occasions did the defense counsel say, Judge, I think they want a definition of that. And I think they may be stuck on emission. Can you explain to them what that means? At no time did that happen. And on both, the court said, I will read to them again the CJI and the definition of sexual contact as it appears in the penal law. And she reread the charge again to them. No one said a thing. So I don't think that that's preserved either.
If that were the case, Your Honor, and that the defense had to make that argument, there's no proof of sexual gratification at either time. There's absolutely no proof of it. So the reality of it is that it's a circumstantial case, at least as to when the ejaculate was obtained. It's not necessarily, it doesn't necessarily mean it came from masturbation. Or at least it didn't come from masturbation from him or from her, which is what the statute suggests. So there could have been a third person. They didn't knock that out. When did this ejaculation take place? Also, there was supposed to be, at one point, somebody testified as to other fluids that were in the specimen. Now, there are other fluids in the specimen. The only one I can think of is saliva. Could it have been that there was fellatio and then...
Well, see, counsel, I mean, now you're getting into another interpretation of emission. If they wanted to be that specific, they would have been. But emission, the off-putting of something. So it doesn't have to necessarily be through ejaculation for sexual gratification. It's the off-putting of it, right?
No, but the sexual gratification is part of the statute. I agree with
Which can be inferred by the conduct, which brings me back to my first point, inferred by the conduct of actually putting ejaculate on someone else.
I don't think it can be inferred that way. It has to be inferred, if there's any inference, that the emission happens at the time that the person is sitting there. Or is standing there, whatever you want to say. That's the time of the ejaculation. That's the time of the gratification. And that's not what happened here.
Thank you.
Thank you.
Largo versus Stern.
Counsel, wait up. You have the bag?
Good afternoon, Your Honors, and may it please the Court. I'm Adrienne Koch for the defendants' appellants. There are 3 issues on this appeal, and subject to the Court's questions, I plan to address them in the order in which they appear in the briefing, starting with the bond. Justice Ostrager gave 2 reasons for directing the defendants to post a $1 million bond. The first was to secure against any possible future monetary relief the plaintiffs might be entitled to, and the second was for what he called a whole cacophony of alleged and apparent sins.
So can I ask you,
Yes.
the judge did make that statement that seemed to go off on something else, but with regard to the main part of what he said, doesn't he have the ability to impose a bond to deal with the issues with regard to litigation and make sure that it proceeds efficiently?
So, Your Honor, we believe that the case law is very clear. Courts do not have open-ended roving authority just to impose a bond. There are certain statutory or rule-based reasons why they can impose sanctions or a bond or an attachment. To secure relief, you need to meet the statutory requirements for an attachment. They are strictly construed.
Hey, counsel, let's break that down, because you just mentioned 3 very different things. You mentioned sanctions, you mentioned attachment. The question before us is clearly the grounds for an attachment were not met. The court was not structuring as the sanctions, so the question is, does the court have authority separate and apart from an attachment or a sanction situation to issue a bond? And there does seem to be case law suggesting that a court does have that inherent authority to issue a bond, even in the absence of issuing sanctions or issuing attachments. So why was it inappropriate in this case, based on the court's explicit finding, putting aside his comments, that there had been litigation misconduct, that attorney's fees had already been ordered and were going to have to be paid, for the court to require the issuance of a bond in this case?
Your Honor, I don't believe that attorney's fees had already been ordered. I think the judge's order, Justice Ostrager's order, denying the attachment also declined to award attorney's fees, and that's on the first page of his order. There was no attorney's fees that had been ordered, and so the bond, in the same order in which he declined to award attorney's fees, we respectfully submit he can't then direct a bond to secure the attorney's fees that he had specifically declined to award. And the AG ship maintenance case, which is discussed in our reply brief on pages 5 to 6, makes clear that once a court decides not to award sanctions under any statute or court rule, it does not have the inherent authority to fashion some kind of other remedy for some kind of litigation misconduct.
Well, aren't there cases that seem to indicate that the court does have that inherent authority, based on both CPLR 3017 and State v. Barone? Doesn't that case and that CPLR provision suggest that the court does have that inherent authority to issue a requirement for bond, even in the absence of awarding sanctions or attachment?
They don't, for the following reasons. CPLR 3017 is about the relief a court can grant in connection with an adjudication on the merits, not as a provisional matter to secure potential future relief. And in State versus Barone—
So where are you getting that? Because it's a very broad provision. The language is extremely open-ended. Where are you getting the argument that it's limited to provisional?
Well, first of all, it's located in the section of the CPLR that is about pleadings and remedies.
Isn't it a catch-all type of provision?
I'm sorry, say that again?
Isn't it a catch-all type of provision?
No, Your Honor. With all due respect, provisional remedies are dealt with in Article 62. And what you can do in order to secure the Credit Agricole case in the Court of Appeals is very clear about that. Courts cannot fashion remedies to secure
But the court there wasn't talking about this issue of whether a court has inherent authority to fashion its own remedies or impose a bond. The court didn't address it one way or another. It didn't say the court doesn't have the authority. It wasn't addressing that issue in that case.
In AG Ship Maintenance, the court was addressing inherent authority and was very specific about the fact that you are limited to statutes, what is in a statute or in a court rule, and the court doesn't have the ability to stray beyond that. And in the Barone case, I see my time is up, but I'll try and answer your question. In the Barone case, it was after a trial. I believe it was a 12-day trial. There had been a direction that the defendant remediate the illegal landfill, and the bond was imposed to secure the relief that had been ordered after the trial. Here, we have not been, there's been no relief ordered against us. There are claims that they're seeking to secure. The remedy for that is an attachment. It is not a bond once you find that the statutory prerequisites for attachment are not met.
Thank you. You have some rebuttal.
Thank you, Craig Flanders from Blank Rome, for Largo, the respondent. May it please the court. I want to address the issue of the purported limitation on 3017. There is no case that finds that limitation. There are several cases that applies the inherent authority which is rooted in the New York State Constitution. It's implemented through 3017 of the CPLR. As Your Honor mentioned, there's no limitation on the face of the statute. But here, on several occasions, the courts have applied it in a provisional way. I mean, Barone itself was a bond that was instituted after a trial which found that a landfill had to be shut down. But the bond was actually provisional in nature. What it said is we're going to secure the possibility that there are damages incurred in implementing the judgment to close down the landfill. I'm not saying that you will be entitled to damages or what those damages will be, but pursuant to our inherent authority, we're going to grant that. And that was 1989 New York Court of Appeals. It followed the AG case that was cited, which had to do with sanctions, had nothing to do with inherent authority to post a bond. The First Department, in a more recent case, in DDG Warren, I think it's DDG Warren in the 2016 case, again applied it in a provisional way, saying that when addressing the possibility of license fees under 881 of the RPAPL, fees that were deferred by the trial court, but the trial court said, hey, pursuant to my inherent authority, I'm going to direct a bond because of the possibility of damages. That's exactly what happened here. It's pretty clear, and the opening brief suggests that there's no authority, inherent authority at all to grant a bond outside of the enumerated statutory attachment and other provisional grounds. It's clear that's not the case. There's no daylight between what happened here and what happened in Barone and the other First Department cases that we've cited and a few Second Department cases as well. Why did he issue a bond? Not only had there been a bankruptcy, and
Counsel, hadn't there been two bankruptcy proceedings? One in Delaware and one in the Southern District?
That's right.
They were both dismissed, correct?
That's correct. They were dismissed
immediately. And that was something Justice Ostrager knew well.
He knew well, and it delayed his case, Your Honor.
And so does that lead to some inference, possibly, that the defendants would abuse the bankruptcy process to avoid a judgment, either on attorney's fees or anything else that was secured by the plaintiffs in this case?
It absolutely does, Your Honor, and it creates really an undisputable set of facts that our client is going to be entitled to attorney fees related to the bankruptcy because there is a direct indemnity provision that shifts fees that says if you file an unauthorized bankruptcy, you got to pay fees, not just to my client, who's the limited partner, the member, Largo, but also to the company that incurred hundreds of thousands of dollars because it was put in bankruptcy wrongfully.
But on the other hand, Judge Lane did not impose attorney's fees himself, correct?
That is not correct, Your Honor. At the time of this record, Judge Lane had indicated he was going to assess attorney's fees. After the time that this motion was heard, I believe, he did indeed award fees and directed a quantum with respect to those fees as part of the remand. But that's separate and apart from the fees that are secured by this bond, which have to do with the Delaware dismissal, fees to my client as well as to the entity, and then there's yet a second bucket of fees, or another bucket of fees, associated with millions of dollars that Mr. Stern paid to defend himself and indemnify himself in the TONA action, which Justice Oestreicher, on summary judgment a year before this decision was made, has said he was not entitled to do. So that money, by way of restitution, is going to have to come back into the pot in yet another case in the First Department, the A&F case. The court found that, pursuant to the inherent authority, that the court could actually, on a provisional basis, say, you got to pay attorney's fees back that shouldn't have been paid during litigation. If they can do that pursuant to the inherent authority, certainly Justice Oestreicher was warranted in bonding off those potential fees. If there's no further questions, I'll rest on my brief. Thank you.
Just to address the points that Mr. Flanders made, the Barone case, the court did order a bond. Again, it was after trial, and the court specifically found that there were extraordinary circumstances. It located the authority to award a bond in the legislative grant of authority to the Department of Environmental Control, and it had made findings that the defendant, regarding the defendant's recalcitrance in complying with prior orders of the DEC.
What about DGG Warren, which was mentioned by opposing counsel?
Correct. That was a case under RPAPL Section 881. That statute expressly authorizes, that's about entering into adjoining land to make repairs to your own property, and it expressly authorizes the court to impose such conditions as may be just when it authorizes someone to enter adjoining land, and a bond has been found to be one of those conditions. So that, again, is statutorily authorized. All of the cases cited in respondent's brief under CPLR 3017 involved awarding relief after an adjudication on the merits. None of them involved provisional relief, which is what we're talking about here. Regarding the bankruptcy and regarding attorney's fees, the court, Justice Oestreicher expressly found that there was no, just declined to award the attorney's fees that they requested, and also expressly found that there was no risk that an ultimate judgment would not be collectible. That's the reason why he declined to award a bond. That finding is unappealed. So without a finding that there's a risk that you might get a judgment that's uncollectible, I'm sorry, it's the reason why he declined to award attachment. I believe I misspoke. Without a finding that there's a risk that a judgment is going to be uncollectible, there is no basis for attachment, and you cannot substitute a bond for an attachment that you're not entitled to. I see my time is up unless the court has other questions.
Thank you.
Thank you.
People versus Neftali Thomas Diaz.
Good afternoon, Your Honors, and may it please the Court. Nicole Giuglas, Center for Appellate Litigation, on behalf of Appellant Neftali Thomas Diaz. Because Mr. Thomas Diaz was subject to the supervision and oversight of the case's Court-Based Intervention Resource Team, or CIRT program, when he was released into the community, 15 points.
When he was in that program, that was pre-plea? That was before he took a plea? I mean, before he was sentenced, rather. There was a conditional plea.
Yes, it was prior to his formal sentence, correct.
Okay. And the CIRT program is not parole or probation as is contemplated by the supervision, when they're talking about supervision in SORA, right? That's a program that he goes to every day, but it's not parole or probation.
It is not controlled by New York State Parole or Probation Department, but the guidelines do not refer only to parole and probation supervision under Factor 14. They refer also to release under the exact language in the guidelines is, will be released under the supervision of a probation, parole, or mental health professional. And the Cases CERT program is a mental health supervisory oversight program. Because the guidelines and Factor 14 are centered on what is the quantum of supervision and oversight of a registrant at the time of their release to the community.
At the time that he was released into this CERT program, was he subject to SORA at that point? Or was it upon his sentence?
Subject to SORA in the terms of, was he required yet to register?
Right.
No, not yet. The SORA statute, the way that it applies, it requires certification at sentencing and then a SORA hearing. In his case, because his formal sentence was one that involved a conditional discharge, a SORA hearing approximately 45 days after being given notice of the hearing. But again, the guidelines and Factor 14 are concerned with when an individual is going to be released into the community, what support, what supervision do they have? And when Mr. Neftali Thomas Diaz was being released from jail into the community, he was being supervised, and for that reason, Factor 14 points were not appropriate. The prosecution's reliance on the sentence and whether the sentence included a component finds no support in the guidelines themselves, because the guidelines, again, focus solely on release and release environment. I see my time is up. I will save the rest for rebuttal. Thank you.
Okay.
Good afternoon, may it please the court. Megan McLaughlin for the people. As the appellate term already found, the court properly adjudicated this defendant a level 2 sex offender based on his repeated and consistent sexually deviant behavior, the type of sexual contact he committed against strangers, and the fact that he—
Well, counsel, why don't you address the fact that he was released to this CERT program, and your adversary is indicating that that was, in fact, a release that was contemplated by the guidelines, and therefore any other supervision wasn't required. He shouldn't have been assessed points on the Factor 14.
Yes, Your Honor. The program that the defendant completed post-plea was not contemplated by the RAI under Factor 14 for actually 2 reasons. Number one, as this court has already referenced, this was not a supervising program, or it's not the type of supervision that Factor 14 contemplates. As was already discussed, the type of supervision that is contemplated is probation, parole, or supervision by a mental health official. Now, even if we're not talking about one that is specific to a sex offender, which is the difference between 15 and 5 points under that factor, there's no indication that this program even entailed the type of supervision that would be contemplated under Factor 14. That's outside, of course, the fact that this was a program that the defendant completed pre-judgment, as this court has already pointed out. Now, the program itself was completed as a condition to even have the judgment that was rendered in the first place. Upon his actual release, which under Factor 14, as opposed to Factor 13, contemplates, the defendant was released and the only condition, or I'm sorry, he was released and sentenced only to time served, a fine, and to abide by an order of protection. So this is not the type of program. In fact, Factor 14 specifies that it contemplated including a program as the type of supervision that could be required, and actually rejected that because it is not the same thing as supervision.
If I hear you correctly, are you saying that the risk assessment instrument is already taking into consideration the fact that he completed this program? That he was released to the program and that he completed it, under factor 13 because he was not assessed any points there.
Yes, Your Honor.
And that now that he's finally sentenced, now under factor 14, he should be assessed the 15 points because he's got absolutely no supervision.
Correct, Your Honor. The conduct that the defendant engaged in, which included the completion of this program, rendered an assessment of 0 points under factor 13. If there are no further questions from this court, I rely on the people's brief.
Thank you.
To briefly clarify the interplay between factors 13 and 14, they are not independent in the way that respondents suggest that they are. Factor 13 in the board's guidance specifically notes, for example, if you are an out-of-state registrant who was subjected to parole and did not have any violations on parole, then you would get no points under factor 13. Because you were subjected to parole at the time you were released for the SORA qualifying offense, you would also not get factor 14 points. And so in this case, the fact that Mr. Thomas Diaz did not receive points under factor 13 says nothing as to whether he should or should not receive points under factor 14. Because when he was released to the community, he was released under the supervision of a mental health professional, the cases CERT program, factor 14 points were not appropriate. Thank you.
Thank you. Taxi Tours versus Go New York.
Good afternoon, Your Honors. May it please the Court, I'm Maurice Ross from Barton LLP, and I represent the appellant, Go New York Tours. This case has two issues. The first issue involves the dismissal of antitrust claims, and the second involves personal jurisdiction. I will address the antitrust briefly first. The Donnelly Act, Your Honors, was not intended to be a mirror image of federal antitrust laws. It was intended to be broader. And that's why the courts have uniformly held that the pleading standard under the Donnelly Act is more liberal than the pleading standard under the federal antitrust laws. In this case, we respectfully submit that the trial court incorrectly dismissed this action on the pleadings at the motion of dismissal phase.
The court seems to have indicated that there was not enough specificity with regard to the claims made in the Donnelly Act, which is why they granted the motion of the counterclaim defendants to dismiss.
Yes, Your Honor. And
why was that wrong?
It was wrong for two reasons, Your Honor. The Donnelly Act, unlike the Sherman Act, includes the word arrangement. We submit that the pleadings more than adequately.
But you used the word conspiracy, arrangement, whichever, it's still conclusory. What did you do to elaborate on whatever?
Yes, Your Honor. The trial court found that we only alleged parallel conduct. That's not so. And let me get right to the heart of this. What we alleged here was much more than parallel conduct. What we alleged was with respect to specific attractions, the two defendants, in many cases, one or the other defendant had exclusive rights to this attraction. And in many cases, for example, the Empire State Building, Big Bus had exclusive rights, and yet Big Bus allowed Gray Line to share that attraction. But they excluded Go New York.
How?
Go New York was excluded because each of the attractions decided to, they said they won't do business with Go New York.
Let me just stop right there, because that's a point that I want to make. What, in your pleadings, what factual allegations were there that say, for example, the Empire State Building took that action because of whatever Big Tours and Gray Line were doing? Why, it seems to me that the speculation and the conclusory allegations are all unilateral on the bus companies, but wouldn't there need to be some kind of bilateral agreement under the case law?
Your Honor, I don't believe so. The question is whether, from all of the circumstances, it is reasonable to infer as a matter of circumstantial evidence that there must have been an agreement. Numerous attractions throughout New York City refused to do business with Go New York.
When? Did you put that inside your pleadings, like specifically?
Absolutely. The time period is crystal clear in the pleading. This is from 2012 until the present time. And we've pled.
I mean, how did you demonstrate that the reason why they didn't want to do business was because of what you're saying? I mean, there's nothing that says, there's no, I don't
Your
know,
Honor,
statement, affidavit, specific acts that they did, something that, any discussions with anyone, something that is more than just saying they stopped doing business because they were working with the other ones to,
Your Honors, the reason that should be inferred is that it makes no rational sense whatsoever for all of these attractions across New York City to refuse to do business with Go New York. Go New York Tours became one of the largest competitors in the market. Why would these entities
How many attractions are, I'm sorry, Counsel, to interrupt. I didn't count that many attractions. It was about a half dozen, wasn't it? Out of all the attractions in New York City.
Yes, Your Honor. We pled examples of about a half dozen, but there are many more. And this is a problem that occurs throughout New York City. The Donnelly Act we submit was designed to encourage competition. And what's happened here is the price that consumers pay for these attraction passes is higher because Go New York is not on the market. I think it can be reasonably inferred from these facts that there is at least a plausible basis to conclude that there was an arrangement or conspiracy between the defendants to keep Go New York out of the market. We're at the pleading stage. This is a motion to dismiss. The question is, should we even be allowed to get into discovery? Your Honor, my time is up. I haven't addressed jurisdiction, but we can stand on the papers on jurisdiction.
You have rebuttal time.
May I continue on jurisdiction?
You have rebuttal time. You will do
Okay,
that.
thank you, Your Honor.
Your Honors, and may it please the Court, Ken Edelson for the Gray Line defendants. I'm going to address the Donnelly Act and tortious interference issues, and my colleague, Mr. Sartorius, will address the jurisdictional issues. I'd like to start to correct something that Mr. Ross said. You absolutely need a bilateral agreement to state a Donnelly Act claim. The definition of arrangement is a reciprocal relationship of commitment between two or more entities that was held by the Court of Appeals in State v. Mobile, and there is nowhere in the appellant's briefing that explains why the facts as pled in the counterclaims amount to a reciprocal relationship of commitment. That's absolutely mandatory to state a Donnelly Act claim. Judge Schechter correctly dismissed the claims under New York law, not federal law. She didn't implicitly or explicitly apply federal law in dismissing the claims. She held that they were not barred as res judicata in light of the federal dismissals. She repeatedly acknowledged Go New York's more liberal pleading standard, and she dismissed under creative trading a First Department case. She did not implicitly apply federal law either. The key basis for dismissal is firmly grounded in New York law. She said there was no description of a conspiracy. That's the second element of a Donnelly Act claim. It also overlaps considerably with the fourth element, which is that you have to have a conspiracy or reciprocal relationship. And what it boils down to is this: if all of the facts in the counterclaims were proven with evidence, there would be a complete blank in that record as to what the bilateral relationship between the defendants is. None of the things that you need that are essential under New York law to state a Donnelly Act claim are there. There's no concerted action.
Did you say there's a relevant market, though? That was, I thought, the weakest part of your argument. It's the hop-on, hop-off bus industry, which is 3 actors, and there's this added component of having deals with various sites in New York City. it seems like a pretty well-defined market to me. Do you want to defend that, or do you want to move on to a stronger point?
Your Honor, we'd submit that allegations in Go New York's briefing contradict that. They allege that many other types of tourist attractions compete with the buses. We'd say you don't need to reach that issue to dismiss because the Donnelly Act claims are not sufficiently
It seemed
pleaded,
like
as
Judge Schechter was
held.
assuming there was a relevant product market, don't you think, in her analysis?
I disagree. She didn't discuss that issue explicitly, Your Honor, and I don't think you need to reach it to dismiss the claims under the Donnelly Act.
No, it's only one element of a Donnelly Act claim. I'm just saying.
That's correct.
Please continue.
So Go New York doesn't allege an arrangement, and the presence of that term in the Donnelly Act does not lower the pleading standard in New York. The creative trading case from 1988 from the First Department held that you can't make conclusory allegations of a generalized conspiracy arising out of the defendant's various business arrangements, contracts, and by reference to unilateral actions taken by them. And that's exactly what Go New York is doing here. And I would note, for Your Honor's interest, this is a matter of public record. If you look at the websites of the attraction passes offered by the three parties, it's clear that a number of prominent New York City tourist attractions do business with all three. The Natural History Museum, the Guggenheim, the Museum of the City of New York, the Museum of the Barrio, are all partnered with all three of the parties here. It's in no way true that they're cut out of all the New York attractions, and that goes to a fundamental problem, which is that they have not quantified any type of exclusion they have out of all of the tourist attractions that are in New York. They allege, as you noted, a small handful that didn't want to do business with them, and there are, of course, plenty of permissible, rational, completely benign reasons why that might be the case.
You want to talk about tortious interference for a moment?
Certainly, Your Honor. The only basis for the tortious interference claim was the Donnelly Act claim. My time's up. We can rest on the brief on that if you have no further questions. Thank you.
Thank you.
Good afternoon. May it please the court. Peter Sartorius for respondent, Big Bus Tours Limited. The plaintiff here, the counterclaim plaintiff rather, asserts personal jurisdiction here under two bases. It's CPLR 302A1 and A3. I'll just address both of those in that order. Under CPLR 302A1, there could be personal jurisdiction over a non-domiciliary where a defendant transacted business within the state and the cause of action arose from that transaction, and neither of those two elements exist here, or certainly neither of those two elements have been adequately pled in the counterclaims as found by the lower court. The counterclaims here, as the judge correctly determined, failed to allege a single New York-based business transaction by the UK entity here, the parent entity, Big Bus Tours Limited.
Counsel, your adversary seems to suggest in his brief that this could all be flushed out in discovery. Should we be waiting for that?
No, you shouldn't be waiting for that. We reference in our brief, and it's in the appellate record here, that there was an opportunity for the counterclaim plaintiff to participate in jurisdictional discovery prior to the motion to dismiss here, and counsel declined, offered no explanation for that, but nevertheless, counterclaim plaintiff's counsel decided to essentially roll the dice with what it had alleged in its pleading, and we respectfully submit that it shouldn't get another bite at jurisdictional discovery now after the lower court found against it on this particular issue. With respect to the transacting business element of 302A1, the counterclaim plaintiff points to what I would describe as a hodgepodge of allegations in the counterclaims.
What about the one about Conway? The person who signed the bus tours, I think.
Right, yeah, they do raise some factual issues about what has been described as an industry guidelines agreement that was executed by the three entities that participate in the big bus tour industry here in New York. And the issue that they raise is whether or not the signatory of that document, when she was executing it purportedly on behalf of Big Bus Tours Limited, the UK entity, whether in fact she had the authority to do so. There's no dispute that she's not employed by Big Bus Tours Limited. There's no allegation that Big Bus Tours Limited actually conducts any business in the state of New York.
Well, that was the suggestion. She signed it, and that's because they do business.
Well, it's, I would argue that, and I think this is really borne out in the briefing as well, that the issue of the industry guidelines agreement is really a red herring here. Let's assume for the sake of argument, well, strike that. Even if Big Bus Tours Limited, the UK entity, is properly a party to the industry guidelines agreement, that by itself is not sufficient grounds to transact business in the state of New York. And if you look at 302A1, it actually makes that distinction between doing business in the state of New York on the one hand and contracting to do business in the state of New York on the other hand. So that by itself, executing a contract with the counterparty that happens to be sitting in New York is not by itself sufficient to trigger personal jurisdiction under 302A1. Moreover, the transacting business element of 302A1 is only one of two elements that's required for a court to exercise personal jurisdiction under that section. The second element being that the claims arise under that business activity, and here there's no allegation. This is not a claim for breach of the industry guidelines agreement. This is, which by the way, just addressed street level conduct by the bus tour operators, the bus drivers, and the ticket sellers and ticket agents that operate on the street. This, on the other hand, is claims by alleged tortious conduct at the corporate level, interfering with prospective business relationships with these various attractions, as well as alleged anti-competitive conduct, again, at the corporate level, as well as false advertising, none of which is touched on at all, completely unmoored from the matters that are addressed in the industry guidelines agreement. And because of that, whether or not the industry guidelines agreement is in fact, does in fact constitute doing business in the state of New York, that second element for personal jurisdiction under 302A1 has not been satisfied, and for that reason, there's no personal jurisdiction under that section. I see my time's up. If there's any other questions, I'd love the opportunity to answer them.
Thank you.
One comment on the antitrust. A smoking gun is not required at the pleading stage. You're saying the court may be suggesting that if we don't plead who, what, when, where, and why conspired at the pleading stage, there's no basis to infer from circumstances.
You're saying it's enough that the fact that they didn't enter into agreements with you should be enough by itself to state a claim? Because
no.
What you have, what allegations do you have other than the mere fact that some of these attractions have not entered into agreements with your client? What else is there?
That for several of the attractions, such as the Empire State Building, either Big Bus or Gray Line has exclusive rights, and yet they allow their competitor, Big Bus or Gray Line, they both share that enterprise. But in every one of those cases, Go New York is excluded. I submit that that is sufficient to infer circumstantial evidence.
But that's not what the case law requires. It's going to require something from the Empire State Building saying that we are also part of this agreement between Go New York, and you didn't plead that.
No, I respectfully disagree. We have pled that the Empire State Building has in fact accepted those terms. We actually have pled that. On jurisdiction, let me just very quickly point out that there are other claims in this action other than antitrust. The court below is considering claims against the defendant Taxi Tours at the moment, and we think it should include Big Bus Limited, for astroturfing, for misleading advertising, and that sort of thing, unfair competition. Those claims are ongoing in the lower court. Big Bus Limited, the UK entity, it is uncontested that they provide operational support in the United States for the United States entity, and they derive substantial revenues from that. And at the very least, we should be permitted to have jurisdictional discovery. May I also say, there's nothing in the record that supports...
Was there an opportunity to do pre-jurisdictional discovery?
So far as I know, we did not. There's nothing in the record to support that assertion. I think there may have been some emails on that issue a long time ago, but that's not correct. We've, in fact, been asking for jurisdictional discovery on that issue. Thank you. I'll rest on my papers unless you have any further questions.
Thank you. Thank you all. Quire versus the City of New York.
Good afternoon, Your Honors. Yetta Curlin from the Curlin Group, here on behalf of Brian Quire, the appellant plaintiff in this matter. Your Honors, the trial court erred in applying collateral estoppel because the issues in the instant plenary action have not been decided in the oath proceeding or in the Article 78 proceeding. It erred in finding plaintiff did not have a private right of action under New York's Constitution by misapprehending controlling law and overlooking the difference between state and federal protections, including theories such as respondent superior, not available under 1983. And the trial court erred by misapplying 3211A by not giving plaintiff every benefit of his pleadings and then misapprehending the requirements to allow him to amend his complaint. I'd like to briefly highlight and correct 2 points respondents raised in their papers. First, regarding the claim that Brian Quire is collaterally estopped from claims here because he already raised these claims in the oath in Article 78's proceedings. As an initial matter, plaintiff did not raise tort or common law claims in either of the earlier proceedings. More importantly, it doesn't matter if Mr. Quire raised the same arguments. It matters only if they were decided in the prior proceedings, which they were clearly not. Quoting from Ryan v. New York Telephone Company, the doctrine of, quote, collateral estoppel precludes a party from relitigating in a subsequent proceeding an issue clearly raised and decided in a prior proceeding. The burden is on defendants to demonstrate a decisive identicality of issues, which defendants have clearly not done here. The drug testing policies that respondents engaged in and their recklessness in implementing them was not before the oath officer. Likewise, this court expressly declined to consider those issues in the Article 78 proceeding.
I'm sorry, counsel, doesn't the collateral estoppel issue have to do with the federal determination dismissing the due process claim as opposed to the oath proceeding? Isn't the issue whether the determination in the federal action dismissing the constitutional, U.S. constitutional due process claims collaterally stops the plaintiff from asserting them in state court?
It is one of the elements of where we believe.
Isn't that the issue before us right now that we have to determine?
It's one of several issues on collateral estoppel because that's just with regards to the constitutional violation claim. Remember, in the plenary action, we claim not only a violation of due process, but also common law claims and tort claims. With regards to Your Honor's question, with regards to federal due process, the 1983 claim that was dismissed by Judge Abrams in the Southern District, as opposed to the New York State constitutional claims, the trial court erred when it determined that plaintiff did not have a private right of action because it asserted it could avail itself of 1983. Therefore, it could not have a private right of action for New York State constitutional laws. But if you look at Talrico and the controlling laws, that is not the case. In fact, if that were the case, those claims would need to rise and fall together, i.e. the judge in the Southern District would have had to dismiss both the 1983 claims and the state constitutional claims. Moreover, despite what respondents say with regards to the virtual identity of those claims, New York State constitutional law offers different protections. Most specific and relevant here.
What is the provision of the New York State due process provision that was violated that was different from the federal one in this case?
Well, the claims are that, specifically under New York State constitutional rights, there are claims of respondeat superior that the state constitution can cover that 1983 expressly does not cover. And if you look at Talarico, it makes that clear. Moreover, the court dismissed all of the claims, the tort claims, as well as the general business law 349 claims and other claims based on collateral estoppel, which clearly did not happen here. The testing policies that are at issue here are not clearly something that could have been brought in the oath proceedings. Psychomedics, one of the respondents, could have possibly been included in Article 78 proceeding. And respondents can cite to nowhere in the record where any of the issues in the instant action were decided in the prior proceeding. So for example, for a negligence claim, did respondents have a legal duty to plaintiff regarding the accuracy of a drug testing? Or did defendants breach their duty of care, so on and so forth? I see that my time is up, unless the court has any specific questions.
You have rebuttal time as well.
Thank you.
Good afternoon, Your Honors, and may it please the court. I'm Alan Racinas, and I represent the respondents, City of New York and New York City Police Department. Your Honors, there are two different claims at issue here that we contend the Supreme Court correctly found are collaterally stopped by issues that were decided previously. The first is the state due process claim, which we contend is barred by the federal district court decision on the federal due process claim. And the second is the negligence claim against the city defendants, respondents here. And we contend that the Supreme Court correctly held, and this is important because the appellant gets this wrong and confuses this, that the hearing officer's decision, the disciplinary hearing officer's decision, in deciding the issue on the legitimacy, the validity of psychomedics testing, that determination collaterally stops the negligence claim. And that's what the Supreme Court held on pages 15 to 16 of the record. And the reason it does that, Your Honor, and this is important because I think all this talk of the other elements of negligence kind of potentially might take one's eyes off of the key issue here, is that it goes to breach. The question, Your Honors, and I'm talking about, so I'm not talking about due process, I'm talking about negligence. The question is, did the city, even if there was a duty to employ proper testing procedures, even if there was causation because of the test, Choir was fired, even if there were damages in the form of lost wages or what have you. The issue is, was there any breach in following these test results and using those relying on those test results to terminate?
Let me backtrack for 1 second.
Yes, Your Honor.
Did opposing counsel even make the arguments regarding the negligence non-constitutional claims in their brief to this court, in their initial brief to this court? I know they made due process arguments, but in their, and I can ask that obviously of opposing counsel, but did they even make any arguments with respect to the negligence claim?
I think they did, Your Honor, but I do think that they kind of mixed the two claims together somewhat, maybe in their briefing. But I read them as at least briefing it, Your Honor, yes. But I think that the important thing to note is, again, the issue of the validity of the testing was decided by the Assistant Deputy Commissioner, who is the disciplinary officer. Most of that hearing, at least much of that hearing, quite possibly most, was about whether the testing was valid. And Justice Kern, you'll remember this from the Article 78 proceeding. The issue there was basically, Choir was saying, well, I'm a drug detective, I'm a detective who deals with drugs a lot. It may have been, the testing was of hair. it may have been that my hair was contaminated externally by by drugs that were in the environment. So there were dueling experts, one from the NYPD, which is Dr. Carnes, the defendant here from Psychomedics, and there was an expert that Choir produced discussing whether or not the testing procedure adequately accounted for the possibility of external contamination. And that issue was clearly decided by the ADC against Mr. Choir. And that's the issue that Supreme Court correctly found has collateral estoppel effects on the negligence claim, because if the testing was valid, Your Honors, there was no breach, because the sole basis for Choir's claim that the city and the NYPD were negligent is the testing was supposedly invalid. Now, on the federal and state due process claims, there is no indication, Your Honors, that there is any difference in federal and state law on that issue. The particular kind of due process at issue here is the pre- and post-termination procedural requirements when an employee loses his or her job. And on that issue, state and federal law, from all indications, are identical. There's no case law directly on the issue, Your Honors, that I've been able to find, but there is a Court of Appeals case that we cite on page 13 of our brief that clearly says as long as there's an adequate federal jurisprudence, the state due process claim is no different. And of course, the federal due process jurisprudence that is espoused in Matthews v. Eldridge and a number of other cases that are kind of classics from law school, Your Honors, is extremely well established, extremely well respected, and there is no state case law indicating that the claims are any different here. In his reply, Choir says, well, the federal court said it was the district court said it was deferring to the state courts to determine this issue. Well, that's true in the first instance, but the court also made clear in that same decision on page 82, I think, that the federal due process determination may well render Choir's state due process determination or due process claim non-viable. And that's exactly what the Supreme Court found here, and that's the correct decision, Your Honors.
Thank you.
Thank you, Your Honors.
Respectfully, it is not appellant who is confused. I believe it is respondents, and I think the best way to explain this is through a hypothetical. Let's assume that somebody is stopped under New York City's policies of stop and frisk, and in the process of being stopped, they're issued a jaywalking ticket. They can appeal that jaywalking ticket. They can fight that jaywalking ticket. But the oath officer who hears that jaywalking case has no authority, no standing, and no jurisdiction to consider the underlying constitutional questions at issue about the flawed policies of stop and frisk. And it certainly does not stop an individual like Mr. Floyd in the landmark Floyd v. City of New York case from bringing a separate action to correct the policies and practices. It is incorrect to imagine that an oath officer made a determination that would be binding upon a plenary action in state court with regards to due process or with regards to negligence. None of the issues that counsel claims are on the record is actually pointed to in their briefs. Those decisions were not made. And the specific issues with regards to the oath proceeding was whether or not the issues presented for termination on the whole of the record were found to be appropriate for that oath hearing officer who is a defendant in this matter. The City of New York is being sued in this matter. One does not exclude the other. And in terms of raising claims, Your Honor, I think you mentioned that Choir had raised his claims. He has told his story both in the oath proceeding, in the Article 78, and now in the plenary action. It's not an issue of raising claims. It's an issue of what the jurisdiction of an oath proceeding, an administrative oath proceeding can decide, what an Article 78 proceeding can decide. And this court has expressly stated in its December 3rd, 2020 decision that it was not and did not have jurisdiction to hear the issues. I know my time is up, but I just want to say one second point, which is that Respondent Psychomedics claims that Choir waived his right to appeal on the tort claims and the common law claims. That is inaccurate. We state our appeal, our right to appeal in the questions presented. We state those claims throughout our brief. And finally, just to say briefly, In conclusion, what the federal court found when declining to dismiss plaintiff's claims other than his 1983 claims are that his claims are important and need to be decided by this state's trial court because they, quote, bear on the state's interest in the administration of its government. And with that, I'll rest unless the court has questions.
Thank you.
Thank you. Thanks for your time.
Thank you both. Long versus Russ.
Good evening. Christopher Helwig of Neighborhood Defender Service for Appellant Danielle Long. Your Honors, this is an Article 78 proceeding challenging NYCHA's administrative termination of Ms. Long's 25-year tenancy. There are two questions before the court. The first is whether or not NYCHA had substantial evidence when it terminated her tenancy on the basis of non-desirability. Specifically, and this is looking at NYCHA's termination procedures, Section 60, 13, and 14. Those are mandated and controlled by the Randolph and Tyson consent decrees. And what they say is that if a tenant presents evidence at hearing that the offender doesn't live in the apartment, that offender has vacated the unit, NYCHA is required to offer, rather than termination, a lesser penalty of probation with a permanent exclusion. And that was what NYCHA was required to do. In order to avoid that requirement, they had to have substantial evidence that the offender, in this case Anthony Newsom, was living in the apartment with his mother, Ms. Danielle Long. However, the record is undisputed.
Counsel, what about the son's statement to the police that he resided at the apartment?
Yes, Your Honor. So first, I'd note that that statement, while acknowledged or stated in respondent's brief, is not really borne out by the record. It is in a police report regarding his arrest.
This is a substantial evidence standard, which you know is a reduced standard.
Yes, Your Honor, of course. But I think that the real focus, to really pivot the court's attention, is not on what Mr. Newsom was doing and where he lived at the time of the conduct, right? That is, I think, a more arguable question. But where he was living at the time of the hearing in 2019. And it is indisputed that Mr. Newsom was incarcerated, which under NYCHA's rules and regulations is enumerated as a grounds to say that he'd vacated the apartment, that he was no longer in the apartment. And moreover, we know where he was going to come back, and no evidence in the record contradicts the statement by his sister at the hearing, Ms. Tia McCulloch, that he was going to move back in with her in New Jersey upon his release.
Additionally, there was a search warrant application that was made that listed his address someplace else, and in fact, that's where he was arrested. But why don't you move on to the reasonable accommodation argument?
Yes, Your Honor. So the second question before the court is whether or not NYCHA acted arbitrarily and capriciously when they terminated her tenancy and failed to consider her reasonable accommodation request. And one thing, again, I want to focus the court's attention. It's not whether her reasonable accommodation request was reasonable. That isn't a question that's right for this court to decide because it wasn't decided by the hearing officer. It wasn't what terms would be reasonable. That, again, was not decided by the hearing officer. It's whether NYCHA violated federal law by failing to consider her reasonable accommodation request. And I encourage Your Honors to look thoroughly through the hearing officer's decision because you'll find no mention, discussion, or conception of the reasonable accommodation request.
Well, doesn't the NYCHA hearing officer go through what NYCHA had done in terms of taking steps to try to work with this individual prior to even getting to this point? Is it sufficient that we look back at that as the hearing officer did, or was the NYCHA hearing officer to look forward and give an additional reasonable accommodation based upon that request?
Your Honor, I think that it was incumbent on the NYCHA hearing officer to look forward and make a determination of whether a reasonable accommodation could be granted. It's certainly based on the things you just described, the previous attempts and the work that had been done in the years past. That's certainly irrelevant to the analysis. But the hearing officer actually had to decide the question. And NYCHA's failure to decide the question meant that Ms. Long had no opportunity to challenge the failure to provide her a reasonable accommodation. And so instead, she's forced to bring an Article 78 challenging the underlying proceeding for failure to abide by federal law, which we would maintain the Fair Housing Act, the Americans with Disabilities Act, and the Rehabilitation Act all make it very clear that NYCHA, and for this standard, I would point Your Honors to Brown v. Popolizio, Stroman v. Franco from this court, that NYCHA is required, pardon me, those were the wrong paper, Feister v. Olatoye in particular is the citation that I want to point the court to. But courts around the country, including from the Circuit of DC, have found that it's timely to make a reasonable accommodation request at the point of a termination hearing. And when that happens, it's incumbent on the housing authority all throughout the nation to evaluate that reasonable accommodation request. And failing to do that means that the decision was reached in violation of federal law and is thus arbitrary and capricious. If Your Honors have no further questions, I'll reserve the rest of my argument for rebuttal.
Good afternoon, Your Honors. May it please the court, for respondent Seth Kramer. I'll first address the issue of the criminal conduct, of the son's criminal conduct. In the Satterwhite case, this court rejected the exact argument that petitioner makes here. The Satterwhite case cited the Supreme Court case in Rucker, which is based on the United States Housing Act, and the terms of the lease incorporate that act. So the policies that petitioner is citing distinguish between offending members of the household and people who are not offending members of the household. And in this case, petitioner herself is an offending member of the household, and that's what this court held in the Satterwhite case. Because under the Housing Act, tenants are responsible for the dangerous and violent criminal conduct and drug-related criminal activity of those in the apartment at the time of the conduct.
Right, but wasn't, and just, you can correct me if I'm wrong, but wasn't the conduct 2 blocks away? It wasn't, the apartment itself wasn't implicated in any conduct. And even the search warrant puts him at a different address, and they knew, presumably that search warrant was based upon probable cause, so they knew where to find him. That was his apartment. So I'm not really following where you're going.
Sure. The conduct was 2 minutes away, but the provisions of the lease, the provisions of the United States Housing Act, the Rucker case, all define the conduct based not on where the conduct occurs. It actually says on or off the premises in the lease and in the statute. It's based on whether you are housing someone who is committing that criminal conduct, regardless of where the criminal conduct actually occurs. Here, the charges are based on it being the administrative charges are based on it being in the vicinity of the housing authority apartment, which is certainly the case being 2 minutes away. And the court in Rucker recognized that tenants who are unable to control the drug crime of members of their household or people living in their apartment are a threat to other residents. And in the Satterwhite case,
Wait, so I just want to clarify. So that is the case whether or not the occupant is aware of the activity?
In Satterwhite?
Yes.
Yes, so in Satterwhite, the court held, and again, this is the provisions of Rucker and the Housing Act, but Satterwhite recognized all that. And Satterwhite said that whether or not the tenant was aware of the conduct, and even though it was undisputed that the ex-boyfriend who had committed the conduct had left the household, the termination was still proper. And this court in Satterwhite said that the termination is based on the tenant's own conduct. Now, the tenant didn't sell drugs in that case. The tenant didn't sell drugs here.
I understand. You're out of your time. So the answer to the question was, yes, the facts are the same. So do you have another point before you?
Yeah, I'll be very, very quick. The Tyson case, some of the Stroman case, that's about guilt by association. That's where the tenant wasn't residing in the apartment at the time. I'm sorry, the offender wasn't residing in the apartment at the time of the conduct, which is distinct here, where substantial evidence shows that the tenant was Anthony Long was living there at the time. Just quickly on the, as we say in our papers, there's no nexus between the alleged disability and the failure to recertify income. She knew what she had to do to remove her children from the household. She didn't do it. There was plenty of outreach done. She told a psychiatrist in 2018, or the psychiatrist concluded in 2018, that it was unclear whether the violations were related to her symptoms. She interacted with staff on plenty of other issues, so it wasn't a matter of her being intimidated. She recertified her income back in 2011, even though the alleged disability stemmed from incidents in 2003 or 2004.
What about the reasonable accommodations? And then, if you could just
Sorry, can you?
With regard to the reasonable accommodations, the court doesn't specifically say, I'm going to address the reasonable accommodations. Is that an issue?
The court, I'm sorry.
The court doesn't specifically say.
Hearing officer.
The hearing officer, that I'm going to, address the reasonable accommodations. But there are some references that suggest that perhaps the court was considering.
Yeah, I don't believe the hearing officer is required to explicitly address every legal argument that's made. The hearing officer noted the claim that she was intimidated and that's why she couldn't go to the hearing office. The hearing officer noted the psychiatrist evaluation. And ultimately, the requested accommodation here was a lesser penalty, a probation, and the hearing officer didn't find that. One quick point on the...
Well, it's got to be a nanosecond because I've let you have so much extra.
I appreciate that. Nanosecond, failure to be certified, just Exhibit 00 is a psychiatric evaluation. After 2011 is when the tenant became employed. So after she recertified is when she first became employed by the Parks Department, I believe.
Okay.
And it's income-based rent, so that might have explained why she hadn't recertified her income. The rent may have gone up had she recertified.
Thank you.
Your Honors, just to briefly address a couple points that were raised. First and foremost, there is no evidence whatsoever in the record that Ms. Long herself was in any way involved in any of the activity, the criminal activity, from any of the...
But is that necessary?
That is necessary, Your Honor. I point to, so in Satterwhite, in Gibson v. Blackburn, the tenant of record was involved to some degree with knowledge or something else of the conduct. Here, the evidence in the record is that in 2017, she sent her son to live with his sister in New Jersey in the hope to basically get him out of the house and get him away from whatever was going on. So the evidence in the record shows that she was not involved, that she didn't want to be involved, and that she actively took steps to try to get him away to protect her community, which is exactly, her goals are the same as Nitra's, a safe community. To address the second point, though, there is not a requirement that there be a nexus between the reasonable accommodation and the thing, though I would submit that there certainly is. It's a failure to submit paperwork. She clearly had issues submitting paperwork since 2011, and no one disputes that. But she had the benefit of a guardian ad litem, of legal counsel, and was certainly in a position at that moment where she might have been able to get herself into compliance with the paperwork if afforded a little bit more time to do so. The hearing officer's failure to address the reasonable accommodation is a failing in the decision because just discussing the past events doesn't resolve their obligation under the Fair Housing Act to affirmatively consider the request and engage in a conversation with the tenant and her counsel about what could work, and if it's not going to work, why it won't work, because that would have afforded her the opportunity to seek to sue and overturn that decision. But that decision wasn't ever reached, and because it wasn't ever reached, the best she could do was say, you didn't decide it. NYCHA's trying to employ a pocket veto here, and I would say it's frankly fairly speculative to say that, as respondent does in their papers, that because in order to terminate her, they needed to consider her reasonable accommodation request. Because they terminated her, they must have considered her reasonable accommodation request. And with that, I can see my time has expired. If there's no further questions, thank you.
Thank you. Thank you both. Bartel versus Farrell Lines and Bartel versus Maersk Lines, and Justice Mendez is recused.
Good afternoon. May it please the court. My name is Anna Stark, New York counsel for the appellants. With me today is my colleague, Eric Daniel, who was admitted pro hoc in this matter by letter order dated April 7th, 2022. Appellants respectfully request that Mr. Daniel be permitted to present the arguments for appellants in this matter.
I will grant the request.
Thank you, Your Honor, for that permission. May it please the court. My name is Eric Daniel, and I'm here today on behalf of the appellants in both cases, ship owners, Farrell Lines, Maersk Line Limited, and Keystone Shipping Company. We're here before you on 4 issues. One of those issues is applicable to both cases. So I'm going to start with that and see where we go. The issue that's applicable to both cases is whether Mr. Bartell and Mr. Peoples had standing to file these lawsuits in the first place. The trial court judge, in denying our motions for summary judgment, relied on 45 U.S.C. 59 in indicating that Mr. Bartell and Mr. Peoples had authority as personal representatives pursuant to the Jones Act. The issue before you then is, what does it take to be a personal representative pursuant to the Jones Act, and was that present here? The case law we cited indicates that a Jones Act personal representative is someone that is, quote, lawfully and properly appointed as executors or administrators of the decedent. So it's not enough to have a state court that has appointed some sort of authority. There's an
We're not bound by that finding in Ohio. That's your argument.
That's my argument. Both that you're not bound in Ohio, but that there's an obligation to actually look into this and see where the jurisdiction is challenged as it is here.
But it was never challenged in Ohio, right?
Correct, Your Honor. Ship owner defendants were never parties to the Ohio probate court. This lawsuit was filed long after that probate court had issued its order, and no steps were taken to formally go back and try to gain some sort of ruling from the probate court, because this is where we're parties in the litigation.
And you're arguing the full faith and credit doesn't apply because we, as a New York court, have the right to look into the original jurisdiction of that court to issue the letters testamentary or the probate administrative.
That's correct, Your Honor. And I think that particular issue was actually raised in the In Re Estate of Kane case that we cited too, where the New York court specifically rejected the full faith and credit argument as it applied to probate court administration.
What about, because I know there's a lot of nuanced questions in this issue, what about the argument that the bankruptcy proceedings were enough property to sustain the representative status in Ohio since some property was required?
Yes, Your Honor. The issue of the bankruptcy claims, first of all, I think it's important to look at the actual application for ancillary administration before the Cuyahoga County Court. Those claims were never listed as Ohio property in the first place. That was something brought up way after the fact. The only type of property listed then was an unknown or unspecified wrongful death claim. So that's different from the bankruptcy claim first. The other issue is, if you're going to look at whether those bankruptcy claims are Ohio property, we still have to look to the underlying issue of whether those arose or the underlying claims arose in Cuyahoga County, Ohio. And there's no evidence that's been introduced on the record that those claims have any relationship to Cuyahoga County, Ohio, other than that they were originally filed in the Northern District of Ohio, which sits in the same county.
What about the argument raised by opposing counsel that even if there isn't ultimately proper papers, that the wives of the deceased plaintiff should be able to be substituted under CPLR 2005?
I'm not sure I heard all that, I'm sorry.
The issue about whether or not there can be substitution of plaintiffs at this point. The wives substituting as a plaintiffs in this action.
Yeah, I mean, that's the reason we're here in the first place, is there was a motion to substitute, and that triggered the summary judgment process.
Why shouldn't that be allowed?
Because it's untimely. I mean, really what we're dealing with is...
So they made an argument about CPLR, I think 2005. Why isn't that applicable?
Yeah, the CPLR provision providing us 6-month additional time. Is that what you're referring to, Your Honor? Yeah, so we cite the case law that says when you have a state provision like 205A that adds to or expands upon an additional or an existing federal statute. I'm sorry?
I said, my apologies, I gave the wrong number.
Oh, okay.
But it can't extend a federal statute of limitations.
Exactly, Your Honor. There are cases, including a case that directly dealt with the statute of limitations for a Jones Act case like we have here that said you can't use that to extend or expand that 6-month, or what's a 3-year statute of limitations to add 6 months to it.
Is there another way to do that under New York law? Would the relation back doctrine apply?
It's our position, no, Your Honor. The fundamental argument we're making is that since the ancillary administration fails on its face, that makes the filing of this lawsuit a legal nullity. And so you can't rely on the relation back doctrine to fix a legal nullity. The only option is to file a new lawsuit, which would be untimely at this point.
Was there any argument about relation back in the plaintiff's papers?
Yeah, the relation back was brought up. I think in the original briefing as well as in the appellate briefing. I do believe we cited to the case law saying that
Was that in regards to the Maersk defendants, or was it in regards to the substitution of the plaintiffs?
I think really as to both, at least as to CPLR 205A, that's not really a relation back, but the primary relation back argument goes to the Maersk entities and whether to allow Farallines into this case, which brings me to sort of issue 3, if you'd like me to skip ahead to that.
They didn't really, did they, let's go back to the original question, did they really make the relation back argument in their initial briefs with respect to this issue about substituting?
Yeah, I don't think it's a traditional relation back argument. We raised it more in our opposition, or our briefing.
They didn't really raise it in there.
Yeah, it's more as to the Faralline issue, as to the auto claim.
Is this a surprise? This is not really the relation back theory. Is this a doctrine? Is this a surprise? It doesn't sound like it to you.
No, not really. I mean, that's just in litigation generally, relation back is relied upon as a way to try to cure issues that arise like these. Okay. I do have additional arguments, but I'm happy to hold those for rebuttal.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court. My name is Meredith Clark on behalf of both of the plaintiffs' respondents. Yes, Your Honor.
I'm sorry, I should let you introduce yourself. Assuming that we ultimately find that the representatives were not validly appointed, the argument you seem to be making in your papers was that CPLR 205 should allow you to now substitute the deceased plaintiff's wives. But isn't there a problem with CPLR 205 because the federal statute of limitations applies rather than New York statute of limitations for these claims?
I think the argument was that even if the court found that they weren't validly appointed, that in the interest of justice, 205 would, in a later instance, if we were to file a new suit, permit them to be the new substituted appointees.
Right, but the reason you'd be bringing in 205 is because it would otherwise be barred by the statute of limitations, and you're arguing 205 would save it. But that's assuming that the New York statute of limitations applies to these claims. But since it's a Jones Act, the federal statute of limitations applies. So how then would CPLR 205 save the timeliness of these claims if they're otherwise, the representatives were otherwise inappropriately bringing this action?
Sure, Your Honor. I think that the weight of that argument comes down to the procedural versus substantive. And Jones Act borrows the procedural case law from the court that the case is brought in, and then uses the substantive maritime law for the underlying issues of the case. And so therefore, under the procedural argument, it's a procedural device that would be available to the plaintiffs under the Jones Act.
So you're saying CPLR 205 statute of limitations should apply rather than the federal statute of limitations?
The procedural nature, the vehicle of tolling the statute of limitations.
What's your best case on that proposition, if you have one?
Your Honor, I don't have one right here in front of me at this time. But I don't think you even need to get there, because Bartell and Peebles, we're not looking at whether there was Ohio property in order to find them as the personal representatives in this case. I think that the issue is confused in the appellant's argument. The distinguishment between the special character of a personal representative under the Jones Act as a statutory trustee versus the ordinary common law functions of an executor or administrator. A lot of the case law cited by the appellants in Ohio and New York, the issues raised, there were competing estates in multiple states that were opened, or there were competing personal representatives that were having fights over the claims that could be brought in certain jurisdictions. The defendants here have no interest. They aren't beneficiaries to the Ohio estate. They aren't beneficiaries to either the other domiciliary estates. And they aren't creditors of the estate either. So they don't have an interest in the probate process of this case. And that is
have to have
separate and aside.
standing?
Pardon me?
In order for them to bring this action in New York, don't they have to have standing? Isn't that part of the prima facie showing that they have standing to bring this action, that they are valid representatives?
Correct, and we argue that they are and that they were properly appointed as ancillary administrators. And even if you want
And
to...
that goes to what was the property they had in the state that allowed them to be appointed as ancillary representatives.
Correct, and both of these plaintiffs had cases pending during their lifetime since the early 90s, one in 93 and one in 96, that were filed in the Northern District of Ohio against multiple defendants, and those were transferred to MDL 875 in the Eastern District of
Talking
Pennsylvania.
about the bankruptcy cases.
Pardon me?
You're talking about the bankruptcy cases?
Initially, the cases were not only bankruptcy claims, they were against viable defendants. The state was, at the time the estate was open, the claims against the viable defendants in Ohio had been resolved, but the cases still remained active as to the bankrupt defendants.
Property, that's the property you're talking about?
The survival claim of that property is enough to bring this action, or enough to open the estate in Ohio for Bartell and Peebles, correct?
And did they list that as the property when they actually brought the probate proceedings, the testamentary proceedings?
The administrators only listed the undetermined wrongful death action. They didn't put a number on any type of claims that were remaining in Ohio. However, the undetermined wrongful death, the only action that was left was the survival claims at that point. They had not filed a new wrongful death claim. They hadn't added wrongful death claims to the federal action that arose out of Ohio either. So it was just a general categorization of the claims that were remaining at that time.
So it's your position that in order to, well, it sounds like it's your position that Bartell and
Bartell and Peebles, Your Honor.
I'm sorry, Bartell and Peebles are appropriately in the case without any need to amend the pleadings? Is that
correct? Yes.
What if we find that they are not appropriately in the case? Then what?
If they are not appropriately in the case, then we rely on Section 205 and 203F, the relation back doctrine, to substitute the two widows as the proper administrators of the case.
And did you raise that?
Specifically 203F. Did you raise that in your papers or in the court below?
I don't recall if 203F was specifically cited in that portion of the brief. I do know that relation back was brought up in both the lower court and now in general as to all of the claims that we were trying to substitute.
That was in the context of the defendants, right?
Pardon me?
That was in the context of the defendants and whether or not the defendants could be brought in. That wasn't in the context of whether the plaintiffs had standing. Is that correct?
I'm not, I believe so. I believe relation back, our motion, because it started as a motion for leave to amend, then there was the cross motion for summary judgment. And so in our motion for leave to amend, we argued that the claims in general related back. I'm not sure if we argued specifically that the claims.
It was specific to the Maersk defendants.
Okay.
Just for your information.
But unless there are any further questions.
Thank you.
If it's okay with the court, what I'd like to do is focus on one of the arguments that wasn't raised previously with the limited time I have left, and that is on the second cause of action, the one involving Maersk and those entities, the issue of the statute of limitations for the survival claim. There's a fundamental difference of opinion as to when that cause of action accrued. Respondent's position is until there's been a lung cancer diagnosis that's definitive based on biopsy materials and a pathological staining of those materials, until that definitive diagnosis is made, the cause of action doesn't, or sorry, the claim does not accrue and the clock for the statute of limitations does not start to tick. Our position on that is far less than a definitive diagnosis is needed before the cause of action or the claim accrues and that clock starts to tick. I'll just refer you generally to the...
What about the confusion, though, as to whether the metastasis was caused by the prostate cancer versus the lung cancer. Isn't that enough to at least raise an issue of fact as to the timeliness issue?
In terms of claim accrual, case law doesn't say that we need to know specificity in terms of where a cancer began, whether it metastasized, anything like that.
Right, but if there was still a belief it could be prostate cancer, there would be no reason to believe that was occupational exposure versus it being lung cancer, which could be occupational exposure.
Right, and so our position is it's an issue of inquiry notice. Once the plaintiff or decedent is put on notice of a potential injury, that starts the clock ticking. We don't need more than that in terms of
Don't they have
diagnosis.
to be put on notice that it's specifically exposure caused by occupational exposure? Isn't that what starts it ticking?
Our position is no. And I'll refer you to the Souters case out of the Eastern District of Pennsylvania, which was a maritime Jones Act asbestos case, and this issue came up. And the court in that case said, quote, "A tentative diagnosis activates a duty of due diligence to investigate further both the nature of the injury and its cause." So once you have some sort of tentative diagnosis, even if it's not definitive, that triggers the duty both as to getting a definitive diagnosis and to looking into independently the cause. What I'll say is, I won't go to the specific record sites if I could just finish this point, but the medical records we cited to show that 2 different doctors had indicated to Mr. Otto that he likely had lung cancer outside of the 3-year statute of limitations. There was a discussion about his asbestos exposure during his lifetime and other records in there, which our position is enough to have put him on inquiry notice to start that clock ticking. Thank you.
Thank you. Thank you both.
I'm gonna try. Sort of, I'm just gonna have to run it.
Yeah.
I'd like to talk to you, but I gotta run.
When you get in your Uber, you can do call if you want.
Anna, thanks for